May I please, your lordship?
Yes.
Lordship, item number 13, my lord. I need slight accommodation, my lord. I will do the matter, my lord. Lordship, please could fix the matter at 2 p.m., my lord.
2 p.m.
Yes. Oblige.
All right.
May it please, your lord. And I'm praying for listing of a repetition, my lord. Can it be taken up on first week of December? Dismissal from service, my lord.
For admission.
For this.
First week of December. Third December.
Can it be fourth, my lord, is a hearing day?
So we don't know.
Yes,
Fourth,
third December, my lord.
fourth is not possible.
3rd December.
Third. All right.
Deeply aware.
I would not be in town for the next week. Then I have a way for listing of a content matter tomorrow. It might come a bit difficult.
Contempt.
Content.
Tomorrow.
Otherwise, no urgency. Tomorrow.
Yeah.
Nice, lordship.
May it please, your lordship, I document item 24 with the concern of my friend lordship. Some difficulties, even instructions also sought for, I have not received lordship. First week of January lordship.
First week of January.
Lordship, on
Board was 6.
6 or 7 lordship, 6 or 7.
On the request made by Mr. K. Gogoi, Learned of CGC, matter stands referred to be listed on 9th of January. 9th,
This is the last day.
Lordship on 8 lordship, 8.
8th of January.
Lordship.
Yes,
Lordship.
correct, yes, correct.
One admission letter I would like to mention, lordship, kindly can it be on 8th of December, lord? Second,
Regularization for admission hearing.
admission,
hearing.
admission column, in admission column.
Admission column, 8th,
Yes.
all right.
Your Lordship, I beg to mention for listing of two writ petition of the same petitioner, Lordship. In the second week of December, Lordship.
Second week of December.
Lordship, it was last listed on 20th December 2024, Lordship.
Well, second week is the last week, essentially.
Lordship, any date, Lordship.
All right, 12th December.
Much obliged, Lordship.
Yes,
I would like to mention one admission item, lordship, listing. First,
12th December.
3rd of December, lordship.
12th.
12th December. Can it be, lordship, first week of December, lordship?
What difference does it make? You are not available on 12th. Let it be on 12th.
Lordship, I'd like to mention for listing on WPC in admission term, Lordship.
January? 19 January.
May it please, your lordship, I am praying for the matter to be listed. My agency is unauthorized, serving unauthorized prolonged suspension, my lord. May I pray next week, any date, man? It's a covered case otherwise, man. 270 days as of now. No review has been done. So that is the whole urgency I'm praying before you.
Well, let it be on 8th of December.
8th of December, man. Highly obliged.
For order, that is 1, 2, 3.
If you took into item number
1.
Milord will kindly take this review petition, Milord.
Review, yes. 57.
Yes.
We have heard this matter.
Yes, heard, Lordship. Milord, the simple point is,
Yes.
We have filed our affidavit today and the copy is also served.
Affidavit. Where?
Item 1 in the review petition. Copy is also served to the petitioner.
The review petition, what affidavit is required?
Milord, if your lordship kindly comes to the review petition, Milord, page number 110. This is office memorandum issued by the Government of India. Undersigned is directed to refer to this department's OM dated so and so. Why do its recommendation of committee of secretaries for discontinuation of interview for junior level post in Government of India is conveyed to the central government ministries and departments. Now clarifications have been sought by different department organizations whether decision of continuation of interview is applicable to direct recruitments only, or it is applicable to other modes of recruitment also. It is clarified that decision of discontinuation of interview in junior level posts in the government is applicable to recruitment to all posts up to Group B, irrespective of the mode of appointment, that is promotion, deputation, etc. Then this was by Government of India, Millard, and page 111 is the OM issued by the Government of Assam. It was on 25/5/16. I am directed to say that the Honorable Prime Minister of India in his speech address to the nation on 15 August announced that the process of holding interview for direct recruitment of junior level post where personality assessment is not an absolute necessary requirement shall be discontinued. In this respect, Honorable Chief Minister has directed that system of holding interview for recruitment of such grade 3 and 4 posts where personality assessment is not an absolute requirement will be discontinued with immediate effect. You are therefore requested to examine the matter in respect of all establishment under your administrative control and make necessary amendment to respective service rule, etc., to discontinue the process of interview for recruitment of grade 3 and grade 4. Now, in this case, my lord, what was originally sought to be done was a concept called digital viva. In digital viva, what happens, my lord, in the screen, the options come. Now, so for example, who is the Prime Minister of India? There will be 4 options. You were to click one. So, my lord, there is objectivity. Now, my lord, in a grade 4 post, interview will be taken by the interview board. What would be the allocation of mark, personality of so-and-so, educational quality? These are all subjective. So,
Well,
therefore, what
this-
had happened, my lord, initially,
This particular OM,
hmm,
page 111,
yes, my lord.
is prior to the interview being held.
Yes. So therefore, my lord, they could not have resorted to interview for the selection. So all that I am praying for is, my lord, Lordship will revive the petition and will make the arguments there. And in spite of exercise of due diligence, we could not bring to the notice of this honorable court these 2 OM. If you could have brought to the notice of this honorable court these 2 OM, certainly, my lord, the decision may have been different.
Now, the government was supposed to inform the court
Yes.
as to whether these OMs are still.
Yes, yes, these are
warranted.
still in vogue, my lord.
Who's for the government? Mr. D. Nath was there.
Well, he is over 1 month on legs, my lord. I will call him, my lord.
अच्छा, इतना कॉपी को. Milord, there is one more OM of the Government of India, Milord. If your lordships would copy that. On last occasion we gave it. Since this is a recruitment of Milord person with disability, now if your lordships would kindly come to the next page, Roman 7. Person with disability should be given option of choosing the mode of for taking the examination, that is Braille or computer or in large print, or even by recording the answers, as examining bodies can easily make use of technology to convert question papers in larger prints, e-text or Braille, and can also convert Braille text in English or regional languages. Now, my lord, Guwahati University has been entrusted to make this selection. What expertise does Guwahati? I'm not saying that they're making recruitment of a college teacher or professor. They're making, my lord, recruitment of grade 4, that to a person with disabilities. These are all specific norms are there. So, my lord, to give legitimacy to a legitimate, a selection process, they're supposed to follow these norms laid down by the government itself.
But that was not your argument,
My lord,
essentially.
No, my lord, my argument is very simple. My argument is, in spite of exercise of due diligence, we could not bring to the notice of the honorable court all these aspects.
So
That itself is a ground for review.
your argument in essence is that whether police recruitment or university, in fact, none was required.
No, my lord, police recruitment board adopted digital Viva.
Right,
Ah.
but if
Half of the thing was done.
no, no,
Midway they aborted it.
you are referring to this page 110.
Yes.
110 does not refer to any interview, digital or anything, nothing.
No, 110, no, my lord, 110 says interview should not be resorted.
Sorry,
That-
111.
Yes, even 111, my lord.
Ah,
They say where the personality assessment is not there, interview component should be discarded.
So therefore,
Ah.
whether it is by digital Viva or what you
No,
know.
my lord, digital Viva has some objectivity, my lord. They started with digital Viva, we had no objection. Halfway through, but the
Digital Viva is also.
no, it's not an interview per se, my lord.
Ah,
Here it is, because these are person with disabilities, my lord, somebody may not be in a position to write also. So ask him to sit in a written examination may not be appropriate. So digital Viva is a procedure whereby,
there was no written examination.
no, nothing, only interview,
Now, digital Viva is scrapped and only interview.
only interview, nothing else.
Yes, where is Mr. Nath?
Lordship, he is placed in call number 1. Lordship,
Alright.
kindly
We'll,
fix another day.
we'll just ask him that and we'll pass over.
Milord, deeply.
Whether this is there or what he has to
Milord,
say.
milord.
We'll call up after a while. If you are available, you can come.
I'll come, Milord. I give also, I have set number one.
List, we call it up after a while. Yeah. Then Mr. Nath comes. Please inform me, we are taking it up in
Lordship,
a while.
Deeply obliged.
For admission, I think 4. 42 crore. No. 42 crore.
Lordship, in this matter, the instruction has been sent for vetting. It is yet to arrive.
Instructions have been sent for waiting or your affidavit.
Yes, Lord. Affidavit.
Affidavit by whom?
By the Cooperation
Corporation
Department.
Department.
It is that,
Yes, madam.
we had asked for records only.
Yes, Lordship.
No, madam, on last occasion, standing council submitted that no register is maintained for Bhavya test.
Uh,
The Lordship directed them to put on record by an affidavit.
When can you file that affidavit?
Lordship, today itself. It
Today?
is on the way.
All right.
Next Tuesday, my lord.
Next Tuesday would be. There are already 90 cases fixed. So we can give you at the earliest is on 9th of December.
My lord.
Matter be listed on 9th. And the respondents on as the respondent council submits that they would file the affidavit during the course of the day. Published accordingly. I think 5 to 8. Ask. Anybody? Yo. With your. Yes.
The engaged counsel, Mr. Elal, is out of station. The matter may kindly be adjourned.
The request is made on behalf of Mr. A. Lal, counsel for the petitioner, that he is not available in station. Matter therefore stands deferred to be listed in the month of January.
It may be listed on 10th of December, my lord.
I'll give you such fixed dates.
10th or 12th, immediately.
10th of December.
10th.
All right, 10th of December.
Much better.
May it please your lordship. Lordship, the state has filed the affidavit and we also have filed our affidavit in reply. I think that, my lord, perhaps the affidavit in reply has not come on record. Although we have filed it now.
You filed, huh?
Affidavit in reply
Uh,
to the affidavit in opposition filed by the State Department.
Counsel for the petitioner submits that affidavit in rejoinder has been filed to the affidavit in opposition filed by the respondents. So same, however, is not connected to the case records. Matter being listed again.
Lordship. A date may be fixed, Lordship.
When did you file it?
My lord, we have already filed it day for yesterday. Even we have given the copy.
12th December.
12th?
12th of December.
Much of them. My lord, I have an interim, my lord.
Whatever is, they will continue till the next day.
Must.
Part two is one take on, then part two is not.
May I pay your lord?
Yes.
As pursuant to an admonishment, lordship, the petitioner was appointed as a jail warder.
Hmm?
Pursuant to an admonishment, lordship, the petitioner was appointed as a jail warder.
Hmm.
This was done in the year 2023. But when he was probation, lordship, he was suspended from service. Lordship, may kindly come to page number 18. Page 18. My name is at page number 19, serial number 14. Raju Thakur, this is my appointment order. This was done on 23rd of May 2023. Then I joined and continuing, lordship. Now, lordship, what happened in the month of July 2023? Annexure 2, page 22. I was suspended because on the allegation that I have supplied some prohibited articles, lordship. Page 22, this suspension order of 17 July 2023. Subsequently, superintendent also, in compliance of DIG's order, issued the same suspension order on the same day, 17 July. Now, pay annexure 4, page 24. This is the so-cause. This was issued on 24th July 2023.
Yes.
Let's kindly see the charges. On such and so, routine checking on entry of warders for shift duty. You have caught red-handed and at jail main gate with contraband articles, particularly so and so, lordship. Hiding under your cap, shirt, pants, shoes, wallet, which are procured by you to supply to the prisoners inside the jail. So you are therefore charged under Rule 298(2)(3) of the Assam Jail Manual 4, involved in supplying prohibited articles to the prisoners. Now, next paragraph, kindly see. You should submit your written statement in defense within 10 days. Now, before completion of these 10 days, the impugn order is issued. The impugn order, lordship, will find at page number 27 and except 5. Immediately after 1 day, this so-cause was on 24th of July. 10 days time have been given to submit my reply. And on 27, lordship, I have been discharged. That lordship will find that.
Did you file any reply?
I have asked him, lordship, that he told me that he submit some reply, but without having any documents or inquiry report. Immediately when he was red-handed, lordship.
But if you have submitted a reply, then where is the need to wait for 10 days?
He told me that he under compulsion, lordship. Even otherwise, the
Get the records, please.
I don't. Record is coming, my lord. The allegation, my respectful submission is that this impugn order is issued on the allegation of misconduct. Now, when the allegation is based on misconduct, then principles of natural justice have to be followed. That is my case.
No, natural justice, if you have already submitted something.
No, that
natural
is
justice
under
is
duress
satisfied.
lordship or compulsion. He told me that
Everything is under compulsion. You have a show cause notice.
is a conflict.
issued.
Kindly go. I have not seen the reply he has filed.
You-
That is
he-
why lordship on the record.
Why is it not shown you a copy of the reply? You are the counsel.
Lordship, immediately, that is why he told me that lordship, he has submitted something, but I asked him lordship to submit, but he could not provide me lordship. So that is why last record was called for. On that day, lordship, my submission was that written statement not filed. Now, when I inquired after the after lordship, he told me that yes, he remember that he some reply filed.
Where are the jail service rules?
The jail service.
Assam jail service rules. So, there is a jail member.
Violation of principle of natural justice does not arise at all. In a case, my lord said, when there is a order passed by the president or governor, there is no scope to appeal, then he has the opportunity to show the appeal filed by him that the charges made against him are not true. This would be a sufficient compliance with the requirements of natural justice. The Maneka Gandhi case also. So he was given opportunity. He did more many. He confessed it, my lord. The last occasion, lordship directed me to obtain the instruction to see the confession and there what they did submit, my lord, regarding confessing the offense. They have said it, my lord. I am getting it like.
How long will it take?
Someone is coming, my lord, from old building to new building.
From Old Delhi to New Delhi?
Yes, my lord. Old building to
Old building.
same thing, my lord. Yes, yes, I got it, my lord. But I have to go through it. You ask me. Oh, চাইছো গুৱাহাটী কাৰাগাৰ অধীক্ষক মহোদয় ৰাজীৱ ইমান কাম কৰিছো তাৰ বাবে মই বহুত দুখী মই বিচাৰি দিছ ইজ কনফেশনেল ষ্টেটমেন্ট আই ডোন্ট নো ৰিপৰ্টাৰ চাইড তাৰপিছত আৰে কি কৰিছে ওলাই দিছো তো মই এইটো That's why, my lord, 10 days, they did not wait for that completed 10 days. They confess it. In the admitted fact and confess it, then, my lord, it is clear case. এইমাত্ৰ দিলোহে মই চালে দিব মই এইমাত্ৰ পাইছোহে কেছটো আনি পেলাই কৈছো দি থৈ গৈছে মোক দিয়া নাই ইনচিডেণ্টটো 16 হৈছে নেকি 16 জুলাই July দিছে they have been placed under suspension by 17 16 already দিছে হেৰি again নাই এই টুপিটা গাঞ্জা ভাং আনিবলৈ হলে আৰু এনেকে হ'ব
You admitted.
Yes, my lord. That was, well, I was directed to, well, to produce these things. What is the writings of the confession? Being a police force, my lord, it a disciplinary force. If they are the, my lord, supplying the ganja bhang to the Koidi prisoners, my lord, it is very heinous crime, my lord. So there are other jail warder also there. But specifically, let's see,
But you have admitted unless you
that
disown
is,
it.
that I admit also because the high officers also became me to. Right,
What can be done now? What can be done? What can be done to say? There are some CDs also.
It's a calls.
Hmm?
CD video, video. Lost to be like. Cigarette, bhang, tobacco, gutka, biri, and level. Tablet hiding their their caps, shirts, pants, shoes, and wallets. What more requires, madam? That was recovered from their and recovered and handled. Or red-handed with the contraband items. A search was made in the barrack of warders and were checking the box Sri Tankeswar Das water and huge amount of contraband ganja was recovered in pocket, which was probably kept ready for supplying to jail inmates, which they have found to be mailingly during the short span of service period. Recently, they have jointly the service started all these things. How can expect malady discipline force malady they will be continuing the service for a long time? The starting point malady. After joining immediately. Joined 1st June 2023 and started working July 23. It is a short span of less than 1 month.
The rules to follow. Jail money. Huh?
Lordship, take up the matter some other day. I have also not gone through these rules also.
Why, if you have not gone through, why did you open up the matter?
Because the book is also not available.
You know,
The police manual is not available also with me.
if it is not available, you should have come. When the records are there, we have seen it, what is there to be argued.
Today is fixed only just to see the records only. Man. Argument already been over. Last time he argued the
I
matter.
heard counsel for party, the records, all four has been placed before the court, the same has been perused. List again on 9th December. The records produced be retained by the government council. We'll dispose it off on 9th.
Lordship. As a part of matter.
Matter be kept as part of.
Lordship. Problem.
My lord, this matter may be taken up after some time, my lord.
Why?
My lord, I am praying on behalf of Mr. My lord, Vipul Castro, my lord. He's on legs in another court.
They will know this is rule, is it? Government, cycle of government. After some time, yes.
Well,
Roshni, can you pass off for time being?
Every matter can be passed over. Why? Why every matter is to be passed over? What is the matter about?
Although here the petitioner is praying for pension,
Pension,
my lord.
pleadings complete.
Some departmental proceeding was initiated against the petitioner, my lord. He says that it was not in terms of the provisions of the Rule 21 of the pension rules. So, yes, come.
My lord, I am a retired employee. Retired in 2017. They invoked Rule 21. They imposed me with a DP without the sanction of the government. Not
When did you superannuate?
2017, my lords. Governor is only competent, my lords. Lordship will see that DC has exercised the power of the governor. Page 22, Annex 7. Whereas, my lords, there was another round of inquiry where I was just given a warning and let off. In the same facts, they initiate second de novo inquiry, and the DC invokes Rule 21. And by the letter 16/7/24, they are seeking ex post facto approval of the governor. Whereas all these years, they have neither paid me my pension, and only recently, my lords, I have been granted this provisional pension. In fact, Lordship has dealt with this in a matter of Mukibul Islam. This is the DC DC code.
The issue relates to what?
Issue relates to my lord, initiation of DP proceedings.
No. DP proceedings initiated for what reason?
My lord, there was some mismatch. They say there was a charge of page 22, my lord, there were some anomalies in records. I was a cashier. They say during my period, I was in charge of the Nazarat branch of the DC of establishment. There was some issue regarding the office records and the cash. That also I could counter, my lord, at page 23 or page 24. I was only the collector. I was only the record keeper, my lords. In fact, that was also a ground for my earlier inquiry, my lord. It is found at page 16, and then, my lord, 17 and 18, my lords. There was an inquiry also, my lord. They found nothing against me.
Where is that finding?
Lordship will kindly come to page. Lordship will follow, my lord, page 17. Is the inquiry. The charge was to I didn't comply with the DC's order with updating the cash book. An appraisal on the cash in hand amounting to dereliction of duty. At the bottom, my lords, the inquiry officer says there is no deliberate mischief on my part. And if lordship goes to page 18, that and DC,
This issue relates to which year?
The pres-
2017.
17,
2007.
17. 17, my lords. But lordship will see the ambiguity in the order which is assailed, my lord.
No, it doesn't reflect here.
Yes, my lord. It is at page 22. It doesn't say at which period what I did.
Page number 17 also it does not
It
reflect.
did not reflect.
The inquiry report does not say.
Even, my lords,
Where is the DC's order for updating cash book?
that is not there, my lords. My lord, leaving aside that earlier inquiry also, if the lordship comes to the second inquiry which I have assailed, page 22, it doesn't say anything. Page 22, my lords.
No, this is the first inquiry.
First inquiry, my lords.
What happened after that?
First inquiry, I was found not guilty, my lords. I was reinstated in the year 2017.
You were warned.
Yes, I was given a warning
Hmm.
and immediately directed to join. Page 18. Then benefits which accrued to me were given to me. Suddenly, my lord, at page 22, lordship at white order dated 2021.
Hmm.
This order was passed. That is also very vague, my lords. That here is the letter. The letter is I don't know. I don't have the letter also. Which period what I did? There's nothing. My ground is very limited, my lords. Admittedly I retired. If you invoke Rule 21, it has to go by sub B1.
You were employed as what?
My lord, I was the LDA.
Senior assistant.
I retired as senior assistant.
Under what provision can the DC accord permission after the person is retired? It is reserved only for the governor.
Yes, Lordship. We have stated in our affidavit on page 31, paragraph 15, Lordship. May I read, Lordship?
Please.
That with regard to the statement made in paragraph 15 and 16 of the writ petition, the deponent does not admit the same and states that the speaking order was issued conducting a detailed inquiry considering it as in continuation of proceedings drawn while Sri Pradeep Chandra Bora was in service. As per Rule 21 of Assam Service of Pension Rules 1969, the order was issued and within Rule 21A, it is empowered that the departmental proceeding was instituted while the officer was in service. The continuation of the proceeding after the final retirement of the officer shall be automatically and no fresh decision nor any so-called notice to the person concerned shall be necessary. The rule is quoted below. Rule 21, the governor of Assam reserved to himself the right of withholding or withdrawing a pension or any a part of it, whether permanently or for a specific period, and the right of ordering the recovery from a pension of the whole, a part of any pecuniary loss cause to the government if any departmental of judicial proceeding the pensioner is found guilty of grave misconduct or negligence during the period of service, including service rendered upon re-employment after retirement provided that a such departmental proceeding is instituted while the officer was in service, whether before his retirement or during his re-employment, said after the final retirement of the officer be deemed to be a proceeding under this rule and shall be continued and concluded by the authority by which it was commenced in the same manner as if the officer had continued in service. Explanation: the continuation of the proceeding after the final retirement of the officer shall be automatically under sub-rule A of Rule 21, and no fresh decision of the governor and or the appointing authority, nor shall any so-cause notice to the person concerned be necessary.
You left out clause B, which is relevant. You have a copy of the rules, pension rules.
Look, wait, wait.
Clause B.
No, last was that. In fact, if lordship goes to last document, but order of 11/9/25, the respondents have said that they are seeking the approval of the governor ex post facto by the communication dated 16/7/24. Admitted fact.
Oh. It isn't. Write the B. Stop the B. Illegal error.
Thousand 2017. Superannuation.
It had 17.
You declared super. DP2.
21. It number one, I had a calculation of confusion. Hold on. Good calculation to bear the metro. Yeah, now can to imagine. It was a stable so
এইটো 12 ফুটৰ আৰু এইটো 11 কৈছে
এটাতো হয়
এইটো হেৰি কনফিউজন লাগি আছে এইটো। পঢ়িলো মই মান খেলি মেলি লাগি আছে। এইটোতো মই কৈ আছো, এইটো মই কৈ আছো, সেইটোত মই কৈ আছো কমপ্লিট। এই যিটো ফিল্টাৰ আছে তাত হোৱাই নাই। হোৱা নাই। Yes.
Yes, that's.
You have seen explanation,
Yes, yes,
clause B.
yes,
So this is a case, it falls under clause B, not under A.
yes,
The earlier proceedings came to a conclusion, he was let off with a warning.
yes,
Subsequent proceedings, you have to show us whether it was initiated prior to his superannuation. It appears from whatever you have stated in your affidavit that it was initiated after he was
yes, super,
superannuated.
yes,
At the time of processing his papers for pension, you noticed certain irregularities.
yes,
And there is a specific bar. See, you see clause B 1 and 4, 1 and 2.
yes,
It must not be more than 4 years before.
4 years,
inception.
yes,
This is also has to be taken into account.
yes,
Your affidavit does not explain that.
yes. In that regard, BJP is silent on it.
And secondly, where does the DC get the power to give initiation for proceedings? The mandate of Rule 21 is absolutely clear.
Yes,
It is only reserved for the governor.
When at that judgment, Lordship is have given Lordship's own has passed this order. Mukibul Islam, para 15, it is dealt with this question.
So we close it.
yes, yes.
But we go party with this vote.
All right.
We'll pass orders.
I also appear in the matter.
Mr. B. Sharma for
Respondent number 480.
Accountant General.
Hello.
MSS Barua for the state.
Stay. Obviously.
14. Item number 14 of 14.
13 लोग ये.
14.
Lordship, kindly the matter be kept for time being. Seniors on next now.
What is this about?
Well, I am an employee with the department and my cadre is in Office of the Chief Engineer. Now, while I was on the zone of consideration for promotion, I am being shunted out to district establishment, which are totally two different rules. And my lords, while during the deliberation we matter, the respondents in the water resource, they have filed an affidavit that my position, my merit, my eligibility won't be touched upon. But whereas, my lords, contrary to that, my lord, they have circulated a graduation list where my name doesn't occur, my lords. And there are two separate different rules, and I have filed affidavits. Additional affidavit, my lord, Government of Assam has completely barred, my lord, the transfer between two establishments, my lord. One is directorate level, one is district level. I am an employee of a directorate level.
Is it barred by any rule?
Yes, my lord. Yes. There's an additional affidavit, my lords. Page 104, it starts. Therein I have annexed, my lords. There's a circulation, my lords. There's a rule. Swagat Satirtha, it's named, my lords, to. It's called Swagat Satirtha, my lords. It's a portal by the government of Assam.
Page number?
The affidavit starts as 104 and then annexes C, my lords, page 117. Therein, lordship will find transfer guidelines, what is allowed, what is restricted. Page 122. What is restricted, my lords? Transfers between, what is restricted? Transfers between directorate / commissionerate and district cadres. I work in a commissionerate, directorate. What is it? No. Okay. Tension for a second. And I'll invite your lordship's attention to page 110, order dated 20/9. But she has some difficulty. She doesn't have the brief. Let her senior come.
After some time, no, sure. I'm not in the case also, I don't.
He's on legs in court 1.
Yes.
Okay.
Lunch open.
Typing item 11.
Heard extensively, your lordship has noted me. This regarding the compulsory appointment.
Civil employment.
Yes. Lordship has noted in the order dated 18/11/25. They have to produce the medical record. Only contention was, my lord, I have clarified as regards my lord maintainability of the petition. And only contention now left to be decided is page 64. He was a driver and he was in civil employment. My lord, it says, my lord, his compassionate appointment ground is that on scrutiny of the medical documents, the husband, the competent medical authority has endorsed fit for civil employment. My lord, the scheme is, your lordship, I have shown at page 27.
There was a finding that is not fit for civil duty.
There is no finding, and my lord, the scheme is, my lord, it is on medical ground only, page 27, your lordship will kindly see. It says, my lord, about top, my lord, about 4 lines. Cause of discharge. Cause of discharge is medically unfit for further service. As your lordship noted.
Yes.
Then page 32, your lordship will kindly see. This is the scheme.
32.
This is the scheme for compassionate appointment.
Hmm.
To whom applicable, 3A/B is retired on medical grounds under so and so. So he has been retired on medical grounds and is retired on medical grounds under rule so and so. And next page, your lordship can you see, page 33, BC is medically boarded out and is unfit for civil employment. So he has been found to be unfit for civil employment. Therefore, he has been given this voluntary retirement. So in
Where is the medical report?
medical report is, my lord, only
Medical certificate.
As the
that besides this.
my lord, last time I not called the medical report.
Yes.
my lord. Yes. My lord, all are regarding the medical board, my lord. Last one is
We
the
can't even, it's not legible.
my lord, last one is the certificate, my lord. Kindly see the certificate. Last one, my lord. The
La-
page.
Last page,
No, I have given the page number 5, my lord.
5,
Last one, my lord. Certificate.
certificate.
Yes, my lord. So and so for fit for civil employee and disability is not likely to interfere in the performance of suitable duties, my lord.
So certificate is given.
Certificate and all are medical related document, my lord.
Certificate says he's fit for civil employment.
Yes, my lord.
Ah,
So, my lord, their case is, my lord, they are relying upon this page number 32. 32 is the of the writ petition, my lord. This is the office memorandum for compensation appointment. So, in page number 33, who are eligible of a member of the armed force who dies during the service is killed is medically boarded out and unfit for the civil employment. That is their document, my lord. So they are relying upon as per BC, my lord. He is fit for civil employment, so he is not eligible for the compensation appointment, my lord. This is our case only, my lord. And that has been given in the year 2012, my lord. At that time, they did not contested this application that he is fit for the, he is not fit, my lord. He has accepted, my lord, at that point of time, my lord. 2012 document is one. That time they did not objected that they did not object that he is not fit, my lord.
page number?
Page number, medical document, my lord.
No, you're referring to some document?
Page number 32,
32 is the scheme.
scheme, my lord.
33 shows the criteria,
Criteria. yes.
eligibility.
Eligibility.
Huh.
So as per clause C, my lord, medically, he is medically boarded out and unfit for civil employment.
So if he is unfit for civil employment, so he is medically boarded out.
Yes,
No,
my lord.
your certificate says you're fit for civil employment.
No, but your lordship will kindly see medically at page 27, medically unfit for further service.
That's right.
Yes.
And the scheme is, my lord, scheme is that if he is unfit for service, my lord, then he is discharged from this. He has
The
provided this.
scheme is
voluntary-
medically boarded out and unfit for civil employment.
Yes.
That is the scheme.
Yes, so if.
So you must be,
reason,
there are two things. One is that you are medically boarded out.
Medically
Yes.
boarded out.
Number two is that you are also unfit for civil employment.
Yes.
Then your dependent will be considered for
Yes.
compulsory.
Yes, so I am.
You are medically boarded out,
medically boarded out.
but your
for the purpose of.
certificate does not show you are unfit for civil employment.
That is medically, for the reasons, that page 27, medically unfit for further service.
Further
Page
service in
27.
armed force, my lord.
Page
27.
27. Medically unfit for further service.
For further
means-
service.
Means further service under the defense.
Yes, ma'am.
Yes, but the whole scheme is that if you are medical for any medical reasons, if you are boarded out, then the.
If this is the scheme, page 33, 32 is the scheme, then 33 is clear.
Your 32, your lordship will kindly see, 32 AB, to a dependent family member of a government servant, A and B, small b, is retired on medical grounds. So for this way, that way, my lord, he is retired on medical ground only. And is retired on medical grounds under so and so. Then a member, then again, the capital B is there, next page, he is medically boarded out and is unfit for civil employment. Unfit for civil employment. It is not for that civil employment because I am unfit for civil employment. Therefore, I have been boarded out.
No, but
For medical reason only I have been boarded out. It is not that I am civil, that fit for civil employment.
You are boarded out under what rules?
Under boarded out, this as per the boarded out because of the medical reason.
Is it under B or C?
That is not
C,
clearly
my lord.
shown, my lord. But even under C, if I go, my lord, but
No,
your lordship,
because we'll need to see into the corresponding rules.
yes,
Rule 2 or Rule 38.
that they have not stated, my lord. So therefore,
Rule C, my lord.
I'm submitting, my lord. Even, my lord, your lordship will get, and is unfit for civil employment. If it is, therefore, even if I go under next page, my lord, page 33, is basically boarded out and is unfit for civil employment. So therefore, I have been boarded out. I am not fit for civil employment, therefore they have boarded. So it
He is
doesn't
not
mean.
fit, he is
No,
not.
no, you see, the problem is that you read the rules. To whom is it applicable?
Yes, my lord.
There are three categories.
Yes, my lord.
Number one is someone who dies,
No, that is not, yes.
including death by suicide.
Yes,
This
my
is
lord.
not applicable.
Yes, ma'am.
Number two, retired on medical grounds under Rule 2.
Yes, ma'am. Possibly.
B, page 32.
52. Yes, my lord.
And number three is retired on medical ground under Rule 38.
Yes, my lord.
So under which category was he, which rule was he retired?
He is returned on the medical ground, my lord.
Therefore.
Under 2
C is
or
the-
Rule 38? Under clause
Yes,
B
ma'am.
or C?
Yes, my lord.
But that paragraph 3 and 4, your lordship may kindly read.
Where is the impugned order?
64.
64.
Discharge or
Competent medical authorities has endorsed that fit for civil employment. If I am fit for civil employment, then the petitioner would have been retained in service as per the scheme.
6 years pension and 6 years medical examination. 6 years rules to compilation of the
In their affidavit, paragraph 3 and 4 may also kindly be read, madam. Or 4, page 49. They said, my lord, disability to the effect of 80%. That while serving with so and so, diagnosed with disabilities, intracranial hemorrhage 1.61 and hypertension so and so, he brought before invalidity so and so, were considered as aggravated by service and connected to military service with net assessment qualifying for disability pension was considered as 80% for life.
My lord, reason is mentioned in page number 22.
And paragraph page 32 and 33, if I take your lordship once again, my lord. It is for medical reasons only they can be granted, my lord, this benefit of compulsion appointment. If somebody goes out of service due to medical reasons and medically boarded out and is unfit for civil.
So, Madam Gayan, I think the clause you are referring to is
Yes.
one of the options. This clause,
Yes, ma'am.
page number 33,
Yes, ma'am.
this is one of the conditions.
Case number 33 B.
32
Yes,
shows to whom applicable.
yes,
There
madam.
are three conditions
Yes,
or
madam.
three situations.
Yes,
One is clause A, one is clause B.
yes, madam.
Now on the clause A, there are three parts.
Yes, madam.
And clause B, there are three parts.
Yes, madam.
So you are saying that it only this third part of clause B is applicable,
Yes, madam.
which the
Can-
perusal of this particular notification does not reflect.
Madam, kindly see page number 22, madam. The reason of his discharge, madam.
No, that reason will come. First, you tell us the eligibility of the eligibility criteria under 32.
Yes, that is, yes, ma'am.
Please tell us that it is only this particular clause which is applicable. Clause page number 33.
Here, madam, as per Department of Personnel Establishment, that is page number 76 of my affidavit in opposition, madam. Clause number 6, serial number 3, madam. Sorry, page number 76, page serial number 3. Serial number 3.
70.
76, madam.
Yes, serial number 3.
Is the scheme applicable to member of the armed force? That yes, department family member and the armed force personnel can be considered for appointment against the civilian post within any establishment or under the Ministry of Defense if the armed force personnel here the C matter is medically boarded out in unfit for the civil
This is
employee.
an interpretation of the rules which
Yes.
we are unable to accept. These particular scheme, you see, each part is divided by an or. So any of these situations.
Yes,
Come to page 32,
yes, ma'am.
clause A,
Yes,
or clause B, or clause C. Or then comes the clause capital B.
clause capital B, yes, ma'am. To whom applicable 3. The dependent family member, clause A or clause B. He comes under clause B, my lord. The clause B medically boarded out in unfit for the civil employment, and he is medically boarded out in the listen out of service under Army Rule 13(3), my lord. This is or, my lord, that A is not come, the clause B will come in our case, my lord.
All right.
And kindly see, my lord, his region of discharge, my lord, in page number 22, my lord. Not in under the civil service, my lord. CCS rule. He discharged under armed force rule, my lord. Army Rule section 13(3)(2).
No, but it is not your case that this scheme is not applicable to army personnel,
Yes, ma'am.
defense personnel. That is not your clause. That is not your case. Your case is that clause B
Clause B,
only
yes.
will apply.
Clause B will apply in our case, yes, my lord.
And you are relying on the explanation given by perhaps the ministry.
Yes, my lord. And clause 3A is, my lord, under CCS rule, but here, my lord, that he was discharged under army rule, my lord. CCS will not apply in our case, my lord. Our apply in this is the description is in page number 77, my lord.
No, but it is not your case that this compassionate appointment scheme is not applicable.
Is it applicable, my lord?
Then
But applicable clause B, C, my lord, medically
that we
boarded
have,
out, yes,
that we
sir.
have understood.
Yes, my lord.
So it is not your case that this compassionate scheme is not applicable to
Yes.
defense personnel.
Yes, that is applicable, my lord, as per this clause, page
So
number
your
77.
case is that in view of the explanation given by the ministry, only applicable to those persons under clause B.
Yes, my lord. That is, yes, my lord. That is our.
Yes,
my lord.
Mr. Das, anything more?
My lord, even if she goes for clause B, I'd like to read this clause B once again.
No, we have read it.
Yes.
Anything more?
It is, somebody will be medically boarded out if he is unfit for civil employment. So this is the case, man. First they say, my lord, this court doesn't have jurisdiction. Now they are saying that he is fit for civil employment. Now he died also in the year 2020.
But my lord,
So
he did
therefore, the whole interpretation given by the impugned order is not correct, my lord, not
my
as
lord,
per
he
the.
even did not challenge
as
the
per the
order
scheme.
dated certificate 26/11/2012, my lord. If he, at that time, if he was not fit for the civil service, he should have come before the court, my lord, or before the authority, my lord, that he is not fit for.
Heard Mr. B. D. Das, Sydney Township, assisted by Mr. B. Purkashkar. Also heard MSC Gayan and CGC. This writ petition is directed is directed against the non-consideration of the claim of the petitioner for appointment under the compassionate scheme. The appointment under the scheme for compassionate appointment under central government, which is published on 2/8/2022. Stop. In facts, shorn of unnecessary details are that the petitioner's father was enrolled in the Indian Army as a driver within bracket capital MT bracket closed on 4/5/1984. Subsequently, he was promoted to the post of Naib Subedar. While he was serving as a Subedar in the army cantonment and posted at Misamari in Assam, he fell ill and had undergone medical treatment at the command hospital in Kolkata. Subsequently, he was discharged on 3/8/2012 with a remark that he was unable to walk due to skull defect within bracket cranioplasty dome, page number 5 and 6. He was recommended for sick leave and review thereafter. It is the claim of the petitioner that during the services rendered by his father, he had rendered his service to the best of his ability and to the satisfaction of all concerned, and was granted several medals and citations for the services rendered. His character at the time of retirement was assessed as exemplary. Okay. However, in spite of the treatment undertaken by the petitioner's father, he could not recover and was therefore released from the command headquarters, command hospital within bracket EC, Kolkata. Subsequently, he was released from service on the ground of medical grounds with effect from 26/12/2012. So, at the relevant point in time, the writ petitioner, and therefore he could not apply for compassionate appointment at that time. So, however, subsequently, the petitioner applied for appointment on compassionate ground on a reading majority. So, the claim of the writ petitioner for compassionate appointment was it rejected or not considered?
Case 64, madam. Rejected.
Was rejected.
Employment exception. Not applicable. They are saying that this is not applicable.
Was
Case
rejected on the ground that the scheme for the appointment under the compassionate scheme applicable for defense personnel are only meant for dependents of the armed forces who died in the harness or medically invalidated out, where the competent medical authority considered the disability as unfit for suitable civil employment. So, upon scrutiny of the documents of the father of the writ petitioner, it was found that the competent medical authority has endorsed in respect of the father of the writ petitioner that he was fit for civil employment. Therefore, employment assistance on compassionate ground is not applicable to the dependents of the deceased soldiers. So, being agreed, the petitioner
Petitioner is the mother of her son, my lord. Why?
the widow of the soldier or the mother of the petitioner filed an appeal before the higher authorities, which also came to be rejected. Being agreed, the present writ petition has been filed. Mr. P.D. Das, learned senior counsel appearing to the petitioner, submits that this rejection is contrary to the scheme itself, referring to the particulars recorded in the pension payment order available and issued to the father of the petitioner, learned senior counsel, submits that the PPO details, PPO particulars reflect the cause of discharge as, within quotes, medically unfit for further service. So he therefore submits that this cause for discharge has to be understood to be in the context of the person concerned, that the person concerned who's discharged, who's medically boarded out, is unfit for both services under the defense as well as for civil employment. So therefore, the claim of the petitioner ought to have been considered in terms of the scheme of 2/8/2022. So referring to the scheme, the learned counsel submits that the scheme provides for consideration of the cases of the dependent members of the armed forces who are medically boarded out and is unfit for civil employment. So, as the particulars reflect that the petitioner's cause for discharge was shown to be, within quotes, unfit for further service, further employment, further service, quotes closed, it has to be construed that he was found to be unfit for both military as well as civil employment. Therefore, the respondents were required to consider the case of the petitioner in terms of the scheme for compassionate appointment dated 2/8/2022, and the rejection of the case of petitioner is contrary to the provisions of the scheme itself. So counsel for the petitioner has pressed into service a judgment of, you have referred to the Allahabad High Court.
Yes,
Allahabad judgment.
as regard jurisdiction of this court.
Oh, this is regarding jurisdiction.
Jurisdiction.
Okay. That we have already,
Yes, and that can be added here because that will be beneficial to the members.
the counsel for the petitioner further submits that the objections raised by the respondents that this court does not have the jurisdiction to deal with this matter, and the matter ought to have been referred to or filed before the Armed Forces Tribunal, is also unacceptable in view of the fact that similar issues have been dealt with by the Armed Forces Tribunal Principal Bench, New Delhi, as well as the Allahabad High Court. So, referring to these judgments, the learned counsel submits that this court is vested with the jurisdiction to entertain the lists before the court and pass appropriate orders as prayed for in the writ petition. Learned CGC, on the other end, strongly objects to the submissions made by the respondents, by the petitioners. Stop. The case of the petitioner is contested by filing an affidavit by the respondents. Stop. The respondents reiterate their contentions that there is no infirmity in the order rejecting the claim of the writ petitioner seeking compassionate appointment, as in terms of the scheme for compassionate appointment, it is only the defense personnel who were medically boarded out and were found to be unfit for civil employment, their dependents are eligible to be considered under this scheme. Stop. According to the learned CGC, the petitioner's father, although was medically boarded out, was not found unfit for civil employment, and therefore there was no infirmity in the orders passed by the respondents in rejecting the case of the petitioner, as petitioner was not declared unfit for civil employment. Stop. The further contention of the respondents are that the department, the Ministry of Personnel and Training, Ministry of the Department of Personnel and Training, Government of India has issued clarification in respect of the queries frequently asked in respect of compassionate appointment. Referring to the annexures enclosed to the affidavit, it is submitted that in respect of applicability of the scheme to members of the armed forces, the ministry admitted that it was applicable subject to the armed force personnel being killed in service or killed in action, or is medically boarded out and is unfit for civil employment. Stop. Learned CGC therefore submits that the question which is before the court has been clearly answered and clarified by the Department of Personnel and Training, and therefore the respondent authorities have correctly considered the same and rejected the claim of the writ petition. During the course of the hearing, the learned CGC has also placed before the court a copy of the medical certificate issued by the medical officer in respect of the petitioner. Stop. Although the certificate placed before the court is not very legible, in respect of the medical opinion. However, the certificate in respect of the medical condition is legible, and it reflects that the father of the petitioner is found to be fit for civil employment, and that the disability is not likely to interfere in performance of suitable duties. Stop. This certificate is issued on 26/11/2012. Stop. Copy of the certificate issued is kept in the case reports, as the same is not enclosed in any of the pleadings. Stop. The learned CGC therefore submits that where the Department of Personnel Training has clearly clarified the position and the medical certificate issued by the medical officer reflects the petitioner is fit for civil employment and that the disability suffered by the father of the petitioner is not likely to interfere in the performance of suitable duties. The petitioner is not suitable to be considered for appointment under the scheme for compassionate appointment. And therefore, there is no infirmity in the order impugned. There is no infirmity in the order passed by the respondents, which is impugned in the present writ petition, rejecting the prayer for consideration for compassionate appointment of the writ petitioner. So, learned counsel for the parties have incurred. Readings available on record have been carefully perused. Judgments cited at the bar have also been taken note of. That at the outset, it is necessary to refer to the scheme itself. The scheme for compassionate appointment under central government reads as under. Is expected, the relevant portion is expected below. Page 33 and 33. From a bare perusal of this scheme, a bare perusal of clause 3 as extracted above is clear that this scheme is applicable to dependent family members of government servant who are classified under clause capital A or under clause capital B. So, although this scheme does not specifically mention that it is applicable to defense personnel, the scheme is also clear that a dependent family member includes a member of armed forces referred to in clause A and B of the para number 3. So, it is seen from the scheme itself that clause capital A contains 3 categories, namely data extract corridor A, B, and C. Page 32. Each of these clauses are separated by an or. Similarly, clause capital B also contains 3 clauses A, B, and C, and are separated by conjunction or. Stop. Reading the scheme in its entirety, there does not appear to be any intent of the rulemaking authority that for grant of Avenue, the clauses A and B clearly reflects that clause capital A is applicable to government servants. Stop. Clause capital B is applicable for members of armed forces. Stop. Note Roman 1 to the said clause reflects that dependent family member includes armed forces. Referred to in within bracket clause A or clause B of this para. And who was wholly dependent on the government servant at the time of his death in harness or retirement or medical grounds, as the case may be. So, so far as the medical certificate is issued, as issued by the medical authorities, the relevant portion, medical certificate, copy of which is placed before the court at the time of hearing of this matter. The certificate issued reflects as under, it will expect from you. This certificate reflects that the petitioner is fit for civil employment and the disability is not likely to interfere in the performance of suitable duties. Perusal of the scheme reflects that note 1, dependent family members, while including armed forces, also makes a reference to clause capital A and capital B in this para. Stop. That is to say that although 3 capital A is shown to be applicable to government servant, and 3 capital B is shown to be applicable to a member of the armed forces, there may be instances where, notwithstanding a person who is a government servant and is covered under clause 3A, at the relevant point of time could have been in the services of the armed forces. Stop. Perhaps this was the intent of the rule-making authority. Stop. The, the scheme also lays down the time frame for consideration of the applications for compassionate appointment. So at clause 10A, it is provided that the request for compassionate appointment, even where the death or the retirement on medical grounds took place long back, say 5 years or so, can be considered by the authorities, keeping in view the concept of compassionate appointment, which is largely related to the need for immediate assistance to the family of the government servant in order to relieve it from economic distress. So, having noted the clauses of this scheme, it is quite clear that there are two categories which are applicable, which are shown to be applicable in respect of dependent family members under clause 3. Stop. Clause 3A is applicable to government servants, whereas clause 3B is saying to be applicable to armed forces. So, since this matter relates to a personnel of the armed forces, for the purposes of this case, the eligibility of a dependent member will have to be examined, keeping in view the specific, the conditions prescribed under 3 capital B. Stop. 3 capital B within bracket C specifically provides that it is applicable in respect of an armed force, member of an armed forces who is medically boarded out and is unfit for civil employment. There is no dispute that the petitioner's father did not die in harness, nor was killed in action. Stop. He was medically boarded out of service. Stop. What is in dispute is whether he is to be considered unfit for civil employment. Stop. The medical certificate which is placed before the court by the respondent authorities clearly reflects that the medical, that father of the late petitioner is considered fit for civil employment, and that the disability is not likely to interfere in the performance of government duties. Stop. This certificate has not been sealed by the petitioners before. The competent authorities of the forces. Stop. The only reference made by the senior counsel for the petitioner is the particulars reflected in the particulars shown in the PPO details. Stop. PPO details reflect the clause as medically unfit for further service. So, in respect of the medical condition of any employee, the certificate which is to be relied on is the certificate issued by the medical professional. Stop. In that view of the matter, the certificate which is issued by the medical officer showing the petitioner's late father, petitioner's father to be fit for civil employment and that the disability is not likely to interfere in the performance of suitable duties has to be relied upon and will have to be given due credence over and above the particulars which are reflected in the PPO details which are enclosed to the writ petition. So therefore, the court comes to the conclusion that the petitioner's, the eligibility of the petitioner has to be considered by the respondents under the scheme of compassionate appointment in terms of the parameters reflected under clause 3 capital B. Stop. 3 capital B clearly, 3 capital BC clearly reflects that the member of the armed forces, that a family member, dependent family member of the armed forces, that a dependent family member is eligible subject to the member of the armed forces is medically boarded out and is unfit for civil employment. Stop. This being the broad scheme, the interpretation sought to be brought in by the counsel for the petitioner cannot be accepted. Stop. Therefore, the claims made by the petitioner that the impugned order be interfered with and set aside cannot be accepted. The rejection of the petitioner by the respondent authorities in terms of clause 3 capital B being in consonance with the scheme itself cannot be faulted with. No interference at this stage is called for. So, however, the question of maintainability of the writ petition, which is raised by the respondents, that it is before an armed forces tribunal, is also turned down in view of the fact that under clause so and so, armed forces tribunal is to look into matters relating to service, which includes appointment. So presently, the petitioner is not in the employment of the armed forces. This is not a challenge made with regard to the conditions of service or any other facet relating to his service under the armed forces. Stop. Presently, the petitioner is not an employee under the armed forces, and therefore the objections raised by the respondents that the writ petition is not maintainable. Writ petition is not maintainable. Therefore, is turned down. It was maintainability. In that view of the matter, writ petition stands dismissed. Order is to close.
Pass this out. Only that page 33. 1 second, madam. I'm just trying to show what is the meaning of page 33. What should be considered because medically boarded out, and if I am in civil employment, if I'm fit for civil employment, my lord, I could
Unfit.
not have been boarded out.
Unfit.
No, and is unfit for civil employment. So therefore, my lord, if I'm unfit for civil employment, therefore I am boarded out.
We don't know. This is what the scheme says. Your
Yes,
medical
and-
services, medical certificate is very clear.
No, I'm not saying medical certificate apart, my lord. I can be boarded out only, my lord, if you are boarded out, medically boarded out and is unfit for civil employment.
No. The scheme is for dependent family members
Who is
who are medically unfit, who are medically boarded out and unfit for civil employment. That is what the scheme says.
yes, unfit for civil employment. If I am fit for civil employment, they will not board me out. That is
That-
my submission.
That is not under challenge.
Yes,
The boarding out of the petitioner's father is not under challenge.
No, that is not compulsory. But medically, because nobody has said, my lord, unfit for civil employment means the persons who have boarded out, my lord. If he is fit for civil employment, he will not be boarded out.
That interpretation from what materials are you drawing?
Because he has been boarded out because he is medically unfit and he is not fit for civil.
No, 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 that is contrary to yours. The medical certificate is placed before the court.
Medical certificate was never given to us.
We have taken note of that.
No, the copy of the medical certificate may be given to us, so that if he wants to challenge, let him
You
challenge.
challenge it. The medical certificate,
It says civil, but as per the medical certificate, my submission is only that if I am fit for civil employment, they could not have boarded me out. That is my submission.
we have recorded you, sir.
Obliged.
Supplementary list for admission item 26.
Yes. Yes.
My lord. My lord, the issue pertains to, my lord, stoppage of the pension. My lord, the petitioner was initially getting provisional pension. Thereafter, my lord, final PPO was also issued. But, my lord, subsequently, without giving any reasons, my lord, the petitioner was stopped. The pension was stopped, my lord. After the stoppage of the pension, my lord, the petitioner represented before the authorities. My lord, thereafter, at page 67, my lord, is the interim order.
Yes.
The relevant portion is at, my lord, page 68, clause G. Now, if I may read, my lord, the government of Assam by memorandum number so and so dated 21/1/19 has directed that the proportionate pension of the ex-servicemen employed in the Assam Police Border Organization is entitled for those who joined on or before 1/2/2005. But in your case, Honorable Court has considered your subsequent appointment on 29/6/2006, 29/6/2006.
You're reading from
Fresh appointment, clause G, my lord,
clause G.
page 68.
Yes.
So, my lord, the authority is relying on a judgment passed by this court, my lord, wherein we have earlier made
Now,
a,
kindly read this entire thing from page 67 onwards.
my lord.
This
With
is a, this is in respect of a representation
my
filed by
lord.
you.
Yes, my lord.
Yes.
My pension was stopped, my lord.
Yes,
so I
please read it.
My lord.
67.
With reference to the above, I am directed to state that on comprehensive scrutiny of your case, the following facts have been surfaced. You signed an agreement of contract service subject to yearly renewal on 12/9/2000. You had been discharged from this contractual service on 23/10/2003 on violation of terms and conditions of the agreement. Again, you have been engaged in agreement of contractual service on 29/6/2006 freshly. Wide Government of Assam order number date so and so order dated 23/9/2011. Your service has been regularized from the date of appointment, that is 29/6/2006, as your break in service is not artificial break in nature. You retired from service on 31/3/2020, but you had not been given benefit of proportionate pension in accordance with the government memorandum number so and so dated 21/1/19, as your appointment of continuous service is considered from 29/6/2006, that is post 1/2/2005. On aggrieved, you have approached the Honorable High Court through filing WPC 2258 of 2020. You have been granted provisional pension in accordance with the tentative view placed in interim order dated 5/4/21 in WPC 2258 in the matter of Chaitra Deka versus State of Assam.
of the Honorable Guwahati High Court. Your service has been regularized from the date of appointment, that is 29/6/2006, as your break-in service is not an artificial break in nature. In this regard, you may refer to the judgment date 17/6/2022 of the Honorable Guwahati High Court in the matter of Chakrabarti Deka versus State of Assam, where the Honorable High Court has considered your subsequent appointment on 29/6/2006 as fresh appointment. The relevant paragraph is reproduced below. In the instant case, the petitioner was discharged from service by the order dated 23/10/2003 by invoking clause 13 of the letter of agreement by which he was appointed, and there is no challenge to such discharge from service by the petitioner. However, by a letter of agreement, he was again appointed in the same post after being acquitted in the criminal proceeding, the reason for which he was earlier discharged upon. On the perusal of the materials on record, it is discernible that the break-in service of the petitioner from the date of discharge on 23/10/2023 up to his subsequent appointment on 29/6/2006 was not an artificial break, but it was a break as because he was discharged from the service in his earlier engagement and thereafter given a fresh appointment after the reason for his earlier discharge stood mitigated. The government of Assam, by memorandum dated 21/1/2019, has directed that the proportionate pension of the ex-servicemen employed in Assam Police Border Organization is entitled to those who joined service on or after 1/2/2005. But in your case,
When did you superannuate?
my lord, 31
2020.
3/2020.
What is the period of service required?
Well, minimum 10 years service is required for grant of
years?
proportionate pension. Yes, my lord.
So you have about 14 years.
Yes, the subsequent service, if it is counted, my lord, it is 13 years, 9 months, 3 days from the date of reinstatement. But the difficulty is, my lord, the respondent authorities have wrongly interpreted the order of the learned single judge. If I may
Where is
take
that order?
page, my lord, 44,
Page?
page 44.
Yes.
Paragraph, I may read, my lord. The petitioner is an ex-serviceman appointed as an ad hoc constable in the border organization. I am reading from
Your-
paragraph 2, my lord.
Ah.
The petitioner, who is an ex-serviceman, was appointed as an ad hoc constable in the border organization under the office of the Additional Director General of Police Border. As per the letter of agreement dated 12/9/2000, the letter of agreement also contained the clause that if an appointee is incapacitated from carrying out the duties on being involved in civil or criminal proceeding, then it may be lawful for the authorities to terminate the agreement. It is stated that the petitioner, in course of his employment, was involved in GR case number 403 of 2003 in the Court of Learned Judicial Magistrate First Class at Lakhimpur. Subsequently, by the order dated 22/3/2006, he is acquitted in the criminal proceeding. In the resulting situation, the petitioner was discharged from service as per the order dated 23/10.
So it was rejected. Your claim for continuous service is rejected.
Yes, my lord.
Did you file an appeal against this?
My lord, my prayer for treating the break-in service as continuous service was rejected.
Right.
Not, my lord, the honorable court has not directed that my date of appointment will be subsequent, because, my lord, my past service prior to reinstatement, that ought to have been counted, my lord, as per rule. My
No,
lord,
but this is not clarified in the judgment.
Paragraph 6, well.
my lord, that judgment is only in respect of the prayer for regularizing the break-in service, not beyond that, my lord.
So what is the effect of that?
Because in that petition itself, my lord, there was a direction to pay pension. If my lord will further take paragraph 12 at page 46, this honorable court has earlier already observed that the writ petitioner is retired from service and is drawing provisional pension. If the order of entitlement of time scale goes in favor, the provisional pension be also modified accordingly. So on the pension aspect, my lord, the issue was not before the learned single judge. The only issue was whether that break-in service should be regularized or not. But what the authorities have now done, my lord, is by wrongly interpreting this order. My lord, they are now treating my date of appointment as the subsequent date of appointment. But my past service, my lord, prior to reinstatement, the 3-year service which I have done, that ought to be counted. My lord, I have stated in paragraph 13 at page 16 that, my lord, minimum 10 years service is required for my lord, with grant of proportionate pension as per rule 108. From 12/9/2000, my lord, that is my date of joining, till 11/8/2003, I have worked for 2 years, 11 months. The period of break-in service, my lord, I am not praying, my lord, because that would not be counted for qualifying, my lord, for the pension, pensionable service. So, my lord, my only player is that, my lord, the date of joining will be 12/9/2000, and my past service has to be counted, my lord, for the grant of pension. For that, my lord, I will refer to, my lord, Rule 63A of the Assam Service Pension Manual.
Yes.
Rule 63A, my lord. Government servant who is dismissed, removed, or compulsory retired from service, but is reinstated on appeal or revision, is entitled to count his past service.
How is it applicable to you?
Because, my lord, my past service prior to reinstatement is from 12/9/2000 to 11/8/2003. The period from 11/8/2003 to 29/6/2006, my lord, that was
Where is your order of reinstatement?
my lord.
Page 30.
30.
30.
That order, my lord, clearly uses the word reinstated, and further, my lord, in the next paragraph, a direction is made as to how that break-in service would be treated. That was treated as dies non, he would not be paid anything for the intervening period of discharge. And, my lord, in the affidavit, in that proceedings, my lord, the affidavit was also filed by the authorities, my lord, at page 72. Page 72, paragraph 5. That, if I may read, my lord, that with regard to the amendments made in paragraph 5 of the writ petition, the deponent begs to state that the same is wholly incorrect. The deponent while letter agreement dated to 29/6/2006, the petitioner was appointed on ad hoc basis for period of 1 year. In fact, he was allowed to serve his duty up to 31/3/2020. However, the period with effect from 11/8/2003 to 1/7/2006 was treated as dies non, and as because no service was provided by the petitioner during the aforesaid period, so far as the termination from the service is.
This is the finding of the court. Finding of the court is that it is a fresh appointment.
Yes, paragraph 6.
No, my lord, that is not, that is exactly, my lord, what we are agreed by. If I may read paragraph 45.
Appeal.
No, my lord, if I may read paragraph 45 again. Whether there is a direction, page 45, my lord, paragraph 7.
Paragraph 6.
6. Yes.
6
and 7, my lord. In the instant case, the petitioner was discharged from service by the order dated 23/10/2003 by invoking clause 13 of the letter of agreement by which he was appointed, and there is no challenge to such discharge from service by the petitioner. However, by a later letter of agreement, he was again appointed in the same post after being acquitted in the criminal proceeding, the reason for which he was earlier discharged. Upon the perusal of the materials on record, it is discernible that the break-in service of the petitioner from the date of discharge on 23/10/2003 up to his subsequent appointment on 29/6/2006 was not an artificial break, but it was a break because he was discharged from his service in his earlier engagement and thereafter given fresh appointment.
Correct. Then you come to the next paragraph.
After the reasons stood mitigated. From such point of view, we are unable to accept the claim of the petitioner that he be deemed to be in continuous service without any break, and to accept the break due to discharge in service to be an artificial break. But my lord, the service prior to reinstatement which I have done as per Rule 63A, which I have read, my lord, that ought to be counted, my lord. Government servant who is dismissed, removed, or compulsory retired from public service, but is reinstated on appeal or revision, is entitled to count his past service.
Yeah, this is not applicable to you.
No, it is applicable, my lord, because prior to reinstatement, I have been reinstated in 2006.
That reinstatement has been read to be a fresh appointment by judicial order. In
No,
your
my lord,
petition.
my lord, in my humble submission, my lord, that is only with regard to break in service. There is no direction by the court to treat the
In
subsequent date as a fresh
The
appointment.
reinstatement order was before the court.
Yes. No, our prayer was to
Your reinstatement order,
No,
was
Lord.
it before the court?
No, Lord.
What, yes or no?
Yes, my lord.
Yes. Now you read 6 and 7 together.
My lord.
The conclusion of the court is that it is a
It is not an
it is not an
artificial
artificial.
And
You
the
read
break.
the last, you read
No,
the
no.
last line.
Yes, my lord.
Fresh appointment was given.
Yes, my lord.
It's not reinstated. For
Fresh
whatever it
appointment-
may be.
My lord.
You may be right that it is reinstatement because that's what the order says.
My lord.
But the interpretation of the court is it is a fresh appointment.
Yes, yes, my lord. But my lord, what would happen to my past
Your
service?
past services will
As
have
per
to
Rule
be
63A,
proportionate appointment will have, pension
As
will
per
have to
Rule
be
60
calculated.
as per Rule 63A, my lord, because the authorities have treated the period as dies known. 63A, my lord, my past service has to be counted, my lord. My date of appointment does not change, my lord. That remains the same. In fact, they have admitted also in their
So
affidavit.
the whole problem is because you have invited problem for yourself. There's an judicial
My lord, that
interpretation.
was not the prayer, my lord. In that
Then-
judgment
then
itself,
you should have taken.
there is a
recourse to-
direction for paying of provisional pension, my lord.
Can we interpret an order passed by a coordinate bench?
No, I'm
You're sitting in.
I'm not interpreting that order, my lord.
Yes.
I am only on my past
Is a clear
service.
finding that it is a fresh appointment.
Yes, my lord, that is correct. But my
What will
past
happen to
service,
what will happen to your past services, etc. was is not even.
yes, my lord, that can be counted, my lord. If I'm relying on, my lord, judgment of this court. It could be. It could be, my lord. I have given the list of books. 2023, 1 GLR.
We don't know what you raised before the court in this matter. The clear finding of the court is that it is a fresh appointment.
Yes, my lord, that is correct. But my past service needs to be counted, my lord. My date of appointment
The
doesn't.
only thing is that you are found to be drawing provisional pension. And if you are found to be entitled to time scale, then
The provisional pension will also increase.
will also increase.
Yes.
That's all.
After, and my lord, already final pension was also issued. What wrong has only been done, my lord, those 3 years has been counted.
No, if it
While
is-
issuing
if
the
it is-
PPO.
if it is not a fresh appointment, then this interpretation will have to be reinterpreted.
No, my lord. My past service needs to be counted. My prayer is not, my lord, that it is not a fresh appointment. It is a fresh appointment. But my lord, my past service as per Rule 63A has to be counted. With my lord, my prayer, my lord, I have also quoted, I have last time, my lord, also I have read. My lord, the prayer was not with regard to pension. The prayer in the writ petition was to treat the break-in service as a to regularize that break-in service. That prayer was only rejected. But my past service, my initial date of appointment, my lord, that remains the same. Or even though, my lord, it is treated as a fresh appointment, my past service of 2 years will have to be counted. And my lord, I am relying on, my lord, judgment of this court, my lord, 2023, 1 GLR 308. Here also, my lord, the petitioner was freshly appointed after a gap of 5 years, but the past service was counted.
Hmm. 2023.
Yes, my lord, 1 GLR 308.
Hmm.
My lord, paragraph 29. if I may read, my lord. In the present case, the petitioner.
Was the initially the facts of the case?
My lord, the facts of the case, my lord, is that, my lord, paragraph 2, the petitioner's case is that he was temporarily appointed as Patwari in the office of the respondent number 9. The petitioner was thereafter sent for training for the recorder's class certificate course in 1982, and after completion of the course, he was given certificate dated 9/6/83. However, the petitioner's service as untrained temporary Patwari was terminated by discharging the service as untrained temporary Patwari, by discharging him from service with effect from 1/7/1982 by order dated 23/6/1982. The petitioner thereafter did not work for 5 years. The petitioner was subsequently temporarily reappointed into service by order dated 11/8/1987 with effect from the date of joining. The petitioner thereafter retired from service on attaining the age of superannuation on 29/6/2002. As no pension or other pensionary benefits was given to the petitioner, the petitioner has filed the present date petition 13 years later, praying for grant of pension and other pensionary benefits. During the course of the proceedings of this case, the respondents came to finding that the petitioner should have actually retired from service on 31/8/2001, and in view of the petitioner's overstaying in service, the respondents sought to recover an amount of rupees 48,069 from the petitioner due to excess pay given for overstaying service. The petitioner's counsel submit that the post of Patwari is a grade 3 post. He submits that as the petitioner has no hand in overdrawal of his pay and overstay in service, the respondents cannot be allowed to make recovery of the amount of 48,069 in terms of the judgment of the apex court. My lord, thereafter, my lord, however, he also submits that the state respondents have to count the period from 1987 to 2001, that is 14 years, 18 months, along with the petitioner's earlier service period from 10/3/1966 till 1/7/82 for the purpose of grant of pension. However, for the period of 5 years from 1/7/82 to 87 was not required to be counted for the purpose of pension, as the petitioner was not in service during that period. The petitioner's counsel submit that having worked continuously from 10/3/1966 to 1/7/82 and from 13/7/1997 to 31/8/2001 in a regular sanctioned post, the petitioner's service has to be deemed to have been regularized. Further, the petitioner having been allowed to go on superannuation retirement, the petitioner cannot be denied payment of pension in terms of Rule 108B of this Assam Service Pension Rules 1969. In support of this submission, my lord, reliance was placed on the following judgments. Thereafter, my lord, paragraph 12. Here also, my lord, the date of appointment was given, my lord, that initially he was appointed on 10/3/1966 without any advertisement. Thereafter, the petitioner service was terminated on 23/6/1982 with effect from 1/7/82, stating that the temporary untrained Patwari was discharged from service with effect from 1/7/82. The petitioner has not challenged the order dated 23/6/82 by which the service was terminated. Now, Lord, thereafter, paragraph 15, my lord, the prayer of the petitioner is that a direction should be issued to the respondents to by the respondents to count his service period from 10/6/1966 till date of his superannuation, excluding the 5 years period from 1/7/82 to 11/7/87, and release the regular pension and other pensionary benefits of the petitioner without recovering the salaries of the petitioner received till 2002. Now, my lord, paragraph 21. Here, my lord, even though the petitioner's service was not regularized, but the past service was counted. In my case, my lord, my services were regularized. In the present case, the petitioner's temporary service was never regularized or confirmed. Further, from the 1969 pension rules does not provide for grant of pension to a temporary employee who retires on superannuation. It only provides for payment of gratuity to a temporary employee who retires on superannuation in terms of Rule 152. of 1969 was provided the employees complete not less than 5 years of continuous service at the time of retirement. Rule 108B of the 1969 pension rules, on the other hand, provides for payment of proportionate amount of pension to a regular government servant who has been in service for not less than 10 years. In the case of Dolly Borpuzari Supra, the division bench of this court has held that the contract employee who was promoted without incorporation of the words on contract service in the promotion order and made to retire on reaching the age of superannuation prescribed for all employees of the state of Assam, whose services were regulated under the rules framed under Article 109, was eligible to receive superannuation pension as the employee was serving under the government in a substantive capacity and permanent capacity for 14.5 years, and as such, disqualification under Rule 31 would not apply to the service of the said employee. The division bench has held that as the employee's service was purely contractual, the only known mode of putting an end to his service would be by stipulation recorded in the contract or by termination of the contract by an appropriate procedure. Now, my lord, coming to paragraph 29. The direction part, my lord.
Yes.
In the present case, the petitioner has been working in a regular sanction post from 1966 to 1982 on temporary basis. Thereafter, his services was terminated and he was reappointed afresh on temporary basis after 5 years. The petitioner was made to retire on reaching the age of superannuation 14 years later. Rule 152 of the 1969 pension rules provide that a temporary employee who retires on superannuation would be eligible for gratuity. This rule has not been put to challenge, and as per the said provision, the petitioner who is a temporary employee can be given gratuity. However, by following the judgment of the division bench of this court in Dolly Borpuzari Supra, the petitioner service can also be treated to have been in substantive capacity in as much as the petitioner service has been under the government in a regular post and he has also been paid by the government till his retirement as per the pay scale prescribed for Patwari. As such, the proportionate pension can be payable to the petitioner in terms of Rule 108B of 1969 pension rules if the governor declares that the service of the petitioner shall qualify for pension in terms of the provision to Rule 31 of the 1969 pension rules. However, there being a 5-year break prior to the petitioner's fresh appointment as Patwari on temporary basis by order dated 11/8/1997, the petitioner's service for grant of proportionate pension will have to be counted only from 11/8/97 till the date of his retirement, that is 31/8/2001. Accordingly, this court is of the view that the disqualification under Rule 31 of the 1969 pension rules would not be applicable to the case of the petitioner herein. In view of the above, this court directs the state respondents to issue a declaration in terms of proviso to Rule 31 of 1969 pension rules to render the service of the petitioner from 11/8/87 to 31/8/2001 to qualify for payment of proportionate pension. Thereafter, the pension will have to be paid in terms of Rule 108B of the 1969 pension rules. So, my lord, even though there was a break in service, my lord, my service prior to the break, my lord, it will have to be counted, my lord, for, my lord, taking into consideration the total qualifying service for the pension. And my lord, if I may take my lord attention to page 82, my area salary,
82 of?
page 82 of my petition. Lord, that document reveals, my lord, that I was paid area salary for that period, my lord, in the year 2019 after my reinstatement. If my lord will see the area period, it is 12/8/12/9/2000 to 31/1/2001.
Yes.
You know that this implies that, my lord, the authorities are treating my service as continuous, except, my lord, that break in service would be treated as dies known for or not granting any service benefits. But my date of appointment is 12/9/2000. This is the area which was granted, my lord. Will see the bill date on the top. It is 10/10/2019. That is after my reinstatement.
Hmm. Yes.
And another judgment, my lord, I am relying, my lord, 2014 1 JLR 666.
Yes.
That is, my lord, with regard to interpretation of Rule 64 and 65 as to what would be the effect of interruption in service. And, my lord, whether the period of absence of the deceased, which was subsequently regularized by the authorities by treating such period as dies non, can be counted for the purpose of pensionary benefit. And the Honorable Court, my lord, held to be in positive my lord, in paragraph 7 is the finding, my lord.
What are the facts here?
My lord, here, my lord, he was a forest guard, my lord. He was appointed as a forest guard. And, my lord, in between, my lord, due to his mental illness, my lord, he could not join the service for a gap of, my lord, nearly, my lord, 26 years. My lord, if I may read paragraph 4, the controversy arose on the following facts and circumstances. The deceased joined the forest guard on 1/5/1956 at the office of the Forest Range Officer Lamding and was continuing in that post in that capacity till 1973 by drawing his salaries. However, he had to remain absent from 14/1/1973 to and 3/5/1990 due to mental illness. After his recovery from illness, he approached the respondent authorities for work. The respondent number 4 again appointed him as Gate Chowkidar on 24/1/1985. Subsequently, he was appointed as forest guard with effect from 2/5/1990. His service was eventually confirmed on 1/12/1995. The deceased retired from service on 31/3/1996 on attaining the age of superannuation. The respondent authorities thereafter counted the total period of service, that is from the date of his second appointment, as 2/5/1990 and to the date of his superannuation on 31/1/1996 to be 5 years, 10 months and 29 days. He therefore received a monthly sum of 2,227 as monthly pension, which was fixed on the basis of his service for the period between 1990 and 1996. It would appear that the period of absence from duty from 14/1/73 to 3/5/1990 was subsequently regularized by the respondent by treating such period as dies non to bridge the gap between the previous service and the existing service without giving the benefit of pay, increment, leave, pension to the deceased for that period. The deceased made the representation to the respondent to count the set period for his absence without leave for the purpose of pension, but the same proved futile. This prompted him to file the petition for appropriate relief. Now, my lord, here also exactly in my case also, my lord, there was a gap in service. Subsequently, I was reinstated and the authorities have treated my break in service period to be dies non. It is clearly reflected in the order of the reinstatement also that the period of break in service would be not be granted for any pensionary benefits or any, my lord, pay or other financial benefits. Then, my lord, the operative part at paragraph 7.
Yes.
As already noted, the letter dated 26/2/2004 at Annexure G, the respondent number 2 has recognized the fact that the absence of the deceased was occasioned by mental illness. Thus, on the undisputed facts on record that the unauthorized absence of the deceased was occasioned by mental illness, there is no difficulty in holding that his absence from duty, even though unauthorized, cannot be held to be willful absence from duty. Consequently, the respondent number 2 has committed an error in law in treating the period of absence from duty of the deceased for the period in question as dies non merely to bridge the gap between previous service and existing service without giving to the incumbent any benefit of pay, increment, leave, pension for that period. The respondent number 2, in issuing the impugned order, has apparently failed to notice the provision of Rule 64 and 65 of the rules. This is non-application of mine. The deceased was under Rule 65 of the rules entitled to have his period of absence without leave commuted retrospectively into leave without allowances. Here, my lord, I am not even praying for any benefits. My only my lord, humble submission is that since the authorities has treated the period as dies non, my lord, that regularizes my period. Only what I will not get, my lord, is the benefits of continuation. And the break in service will not be regularized, as my lord directed by the earlier order of the court, my lord. But my past service, my lord, in terms of Rule 63A, my lord, has to be counted, my lord, because that clearly says, my lord, that a government servant who is dismissed, removed, or compulsory retired from public service, but is reinstated on appeal or revision, is entitled to count his past service. And thereafter, my lord, if I may read clause B also for clarity, my lord,
We'll
that
come back after.
yes.
Just a second.
May I seek a little indulgence, sir? There is this series of matters from 15 to 22. In item number 17, an IA has been filed by the petitioner for implement of 2 new parties. We, on behalf of IOC, we need a little time to take instructions and file a response if
So
necessary.
why didn't you mention it in the morning?
This has not been brought to my notice at all. There's, otherwise we can wait up to.
No. Mentioning is to be done in the morning.
I agree, madam. My difficulty is, madam, there's one matter coming up in code number 1 that is likely to carry on.
That is not our difficulty.
No, I appreciate.
Yes, tell us.
We need a little time to file a response.
I already numbered.
Yes.
Yes, but it is in the list.
3711 of 2025. Item number 17.
Okay.
Lord, we have a small prayer, Lord. Lord, we recollect, Lord, this was a serious matter, 15, 16 and 17, Lord. There was this issue of age relaxation and migration from OBC to general, etc. Insofar as the other matters are concerned, Lord, 18 to 22, Lord, there were separate appointments. In fact, termination was also founded separately, Lord. Can I pray for a detagging of those matters? Because now with the impleadment, Lord, it's bound to linger for some time, Lord. 18 to 22, Lord, has got nothing to do with age. It's a simple matter of termination, Lord. Now, maybe not today, Lord, at least if they are detagged and they're taken up, because otherwise this impleadment is bound to take time. And if
Impleadment of whom?
of
My
the
lord,
general.
the general candidates, my lord,
Hmm.
2 appointed general candidates who have scored lesser mark than us, my lord.
Yeah, what do you say?
So far as this prayer is concerned, my understanding is since it arises out of the same selection process, ultimately separating them might create confusion.
Because 18 to 22 are totally different. In fact, the posts are also different. Only reason they were tagged together was the termination orders were passed on the same day.
What is your prayer in these matters?
18 to 22, can it be detagged and
Why do you want it detached?
because 15, 16 and 17, besides
You were appointed as what? In 18 to 22, you were terminated.
I was terminated.
You were appointed and then it was terminated on what ground?
That there was some manipulation in the marks, etc.
It is
Insofar as 15 and 16 are
Therefore, in these posts, fresh appointments have been made.
no, there's a stay
no,
operating.
there's a
They will stay.
limited interim. What has happened actually is it is at the instance of item number 17, 16 and 17. These at the instance of these 2 petitioners that the terminations have taken place.
Yeah,
So
no,
that
but
is how it is connected.
But insofar
They,
as
they made a complaint and thereafter approached this honorable court.
we'll consider on the next date. You bring it to the notice, we'll consider on the next date.
My lord,
17.
in the meantime, the notice may go in the impleadment application, my lord.
15 to 22.
No, notice will not go today because we are adjourning the matter.
My lord,
We are not upgrading it.
my lord, my lord, my lord.
You did not pray for upgrading.
Yes, my lord.
Item 15 to 22 stands deferred on the request made on behalf of the IOC,
IOC to file a response in the IA. IA trees
enabling them to file an appropriate response in IA number 3711 of 25 filed in WPC 8082 of 2022.
deeply obliged.
The current Mr. B.D. Decker, Leonard Townsend, who represents the petitioners in WPC 1070, 23-7, 1071, 23, 1075, 7677 of 2023. On the other end, submits that these are separate matters and should be detacked from the series. So, at this stage, the court is not inclined to accept the prayers made by Mr. Decker. However, the liberty is granted to the council to renew his prayer on the next date. Let these matters be listed again on.
On 8.
Well, before vacation, perhaps it may not be possible. It's a longish matter. Your lordship may fix it in the month of January. 8th of January.
Part third matter beyond 1 month.
December December
8th? Yes, 8th of January?
8th of
8th
January.
of Jan.
8th of January,
Deeply obliged.
2026.
Lordship, item number 26 to 31, can it be on 9th, Lordship? The next series, Lordship. That DME on 9th, Lordship.
What matters?
That this
It is
DME
related to
matters,
medical
board matters.
CAPF plots.
CAPF matters.
Lordship had disposed of several
Other
matters.
matters 26 to 30 on 9th, Lordship, at 2 PM, Lordship.
What is your difficulty today? Wait for some time.
We
If
can,
it reaches, it reaches.
Lordship.
Yes.
I was reading the judgment, my lord, regarding whether the period of absence of the deceased, which was subsequently regularized by the authorities as dies known, whether it can be counted for pensionary benefit. Now, my lord, another judgment, my lord, I am relying upon.
No, first you tell us the implication of these rules.
Rule
Under which judgment you are relying for interpretation of these rules?
60, Rule 63, my lord. Rules, my lord, Rule 64. An interruption in the service of an officer entail forfeiture of his past service, except in the following cases: authorized leave of absence, unauthorized absence in continuation of authorized leave of absence, so long as the office of the absence is not substantively filled. If his office is substantively filled, the past services of the absentee is forfeited. Suspension immediately followed by reinstatement, which need not be the same office, and where the officer dies or is permitted to retire or is retired while under suspension. Then, my lord, abolition of post or office or loss of appointment owing to reduction of establishment. Then, my lord, transfer of non-qualifying services in establishment under the government control. The transfer must be made by the competent authority and officer who voluntarily resigns. Qualifying service cannot claim the benefit of this exception. Transfer to a grant in aid school entails forfeiture. And then, my lord, Rule 65, which says the authority who sanction the pension may commute retrospectively periods of absence without leave into leave without allowances. So, my lord, in exercise of Rule 64, powers under 64 and 65, my lord, the period of absence was held to be diced on, and my lord, the counted for the pension eventuals.
These judgments that you have referred to does not elaborate on the proposition of 63 and 64.
My lord. Malad, to that effect, Malad, one more judgment.
Swarnamoy is on a different,
Yes. Yes, Malad, I may rely Malad on
there's
one
an
judgment.
authority as to what
63.
consists of an unlawful
Malad.
absence
Yes.
or willful absence.
Malad. No, that I, Malad, just Malad pointed out to Malad, just Malad, tell the Honorable Court, Malad, that the period was treated as dies non and it was counted. Here, Malad, my period has not been counted. It is for those break-in service, Malad, will not be counted for any service benefits. I am only.
That is what Rule 63 and 64 say.
No, my lord, but past service, my lord, here one situation, if I may explain. My lord, prior to my termination, when I was initially appointed, my lord, I was in contractual service. Thereafter, my lord, when termination took place, my lord, I was in contractual service. And when the reinstatement took place, my lord, I was still in contractual service. My lord, the regularization took place thereafter. My lord, to that aspect, my lord, whether, my lord, whether the past contractual service to Malord can be counted towards pension once the service is regularized. To that aspect, Malord, I am relying on the judgment, Malord. It's a on that aspect,
So
Malord.
does it explain 63 and 64?
Yes, Malord, similar rule is there, Malord. In the case of Assam service pension rules, Malord, 63A I have pointed out, Malord, whether past service can be counted or not. Malord, this is the Supreme Court judgment wherein a different rule was under consideration, but the issue was same, Malord. If I may read, Malord, these appeals arise from the Karnataka High Court order dated 23/3/2021, by which it held that the appellant who were initially appointed on contractual basis and subsequently regularized will not be entitled to seniority service benefits and pension for the period of their contractual service. Upon consideration of the relevant rules and decision of this court, in state of Himachal Pradesh versus Sheila Devi, we have partly allowed the present appeals and directed the respondents, that is Union of India, to grant pensionary benefit to the appellants in accordance with law. The short facts as a necessity are as follows. The appellant were appointed as data entry operators under plan scheme called Rationalization of Data Processing Facilities on temporary and contractual basis between 1996 and 1999. Pursuant to an order of the Central Administrative Tribunal dated 1/4/13, the respondents issued an office memorandum dated 5/1/15 to regularize the appellant's service from a prospective date, that is from the date of the issuance of this order. Pursuantly, the appellants were appointed on a regular basis by order dated 1/4/15 with effect from 5/1/15. The appellant preferred an original application before the Central Administrative Tribunal with a prayer to regularize their service from the date of initial appointment or at least from the date of completing 10 years of service, and to protect their pay and to grant seniority service benefits and pension by counting their period of contractual service. The Central Administrative Tribunal allowed the same by order dated 19/1/2016 and directed as follows. Now, Lord, the respondents, thereafter I'm reading from paragraph 4. The respondents challenged the above order by way of a writ petition, which was partly allowed by the impugn order. The High Court set aside the Central Administrative Tribunal's direction to the extent of counting the period of contractual service for the grant of seniority, service benefits, and pension on the ground that the initial appointment was on a contractual basis and not pursuant to the recommendation of the Staff Selection Commission. It held that the appellants will be entitled to regularization and its consequential benefit only from 1/4/15. However, the court upheld the Central Administrative Tribunal's direction regarding protection of pay while fixing the pay scale. We have heard Mr. M.C. Lingaland, senior counsel for the appellant. He relied on this court's decision in Sheila Devi to contend that as per Rule 17 of the CCS Pension Rules 1972, the appellants would be entitled to pensionary benefits by including the period of contractual service. On the other hand, Mr. Vatsal Joshi, learned counsel for the respondents, had sought to differentiate Sheila Devi only on the ground that the initial appointment in this case was not against sanctioned post. Before commencing our analysis, it is necessary to note the scope of the prayer made before the Central Administrative Tribunal, High Court, and before this court. The prayer before the Central Administrative Tribunal is for regularization with retrospective effect, protection of pay, grant of seniority and service and pension benefits by counting the period of contractual service. Pursuant to the High Court's impugned order dated 23/3/2021, only the applicant's pay has been protected while the prayer for seniority service and pension benefits by including the contractual period has been rejected. The submission before this court have been limited to the grant of pensionary benefits by including the contractual period through reliance on the decision in Sila Devi Supra. The issues relating to grant of retrospective regularization, seniority and service benefits during contractual period have not been argued before us. We are coming, we are
These are
there.
interpretation of the rules. These rules is not
Well, Lord, Rule
parameter
se-
63.
Yes, my lord, Rule 17. Rule
Hmm.
17 provides for deals with counting of service on contract for the purpose of granting pension.
Where
Here
does-
also, yes,
Show the parameter rules in the Assam
my lord,
rules.
Rule 63A.
63.
63A, my lord. It says, my lord, the government servant who is dismissed, removed, or compulsory retired from public service, but is reinstated on appeal or revision, is entitled to count his past service.
This is not a case. There was no appeal or revision.
My lord, I have
Entailing
represented.
your reinstatement. of
After
service.
the acquittal, my lord, I have made a representation, and on
But-
that representation, I was reinstated.
That reinstatement has been judicially found to be not continuous service. If you are reinstated,
But I am not on the continuous service. I am on the counting of my past service.
that's what we are trying to
That is
make
on-
you understand, State Council.
My lord.
The judicial order is, the order of the coordinate bench is very clear that there are two periods of your service.
My lord.
You were there in earlier service, but subsequently he was terminated and you were reappointed in
yes,
the
sir.
same post.
My lord.
But the court declined to accept your
But-
contention
Yes.
that it is artificial break
Yes.
or it is a continuous service.
My lord.
So therefore,
But my
whatever you are entitled to, under the rules, you are entitled to. But
But
for you to be entitled to under Rule 63, 64, you must fit into these criteria specified.
My lord, but the court, there is no finding of the court that my past service in the
That
contractual.
was not even an issue.
Yes, that's what, my lord.
Uh,
I am only on the issue that my past service has to be
on
counted
what basis?
on the basis of Rule 63A, my lord.
63A doesn't apply to you.
No, it applies to.
No, it doesn't
It
apply.
applies, my lord, because I have been regularized. My services have been
Okay,
regularized.
show us from the plain reading of 63A how it is applicable to you.
My lord, if I may read, my lord.
Read.
The government servant who is dismissed, removed, or compulsory retired from service, but is reinstated on appeal or
appeal.
revision.
Did you file an appeal against that?
Yes, my lord, I have, after the acquittal, my lord, I have represented to the authorities that I have been honorably acquitted, therefore reinstate me. Therefore, the order of, my lord, reinstatement clearly reflects the fact that I have been reinstated.
But then again, you'll have to cross the hurdle of the judicial order.
But that judicial order is only confined to that period, my lord. Whether my past service will not be counted, there is no mention of that, my lord. In fact, the honorable court in that order itself has explained, my lord, given us the liberty for grant of provisional pension. My past service, my lord, will be counted. My lord, the judgment which I am relying on, Rule 17, is exactly on this point, my lord.
You read page 45's paragraph 6 and 7.
That is, my lord, there is no dispute to that proposition.
So if there is
No,
no,
I am on, my lord, my humble submission is only, my lord, with regard to counting of my.
kindly see para 7. Kindly see para 7.
That is, my lord, only in regard to the continuous service, my lord. If
That's
I
right.
may humbly
That's right.
submit, my lord, but my past service, which I have done, my lord, because my services were regularized subsequently, my lord. Initially, I was a contractual employee. Therefore, my lord, my past service,
We accept your
my
submission,
lord,
provided you show us that the rules permit.
my lord, 63A, my lord, I have been reinstated, if I may again read, my lord.
These
Government servant
This
who is.
reinstatement.
Yes, my lord, I have been reinstated. The order which I have read, my lord, that clearly reflects.
Reinstatement
reinstatement.
has been read to be a fresh appointment by the court.
Yes, my lord, that part is not
Then-
disputed.
Then,
But what
if
about
you are
my-
not reinstated, if it is a fresh appointment, how do you come under 63A?
That's what, my lord. But my lord, my past service during that contractual period, my lord, before the reinstatement, My lord, my humble submission is, my lord, to count that period.
That period will be counted provided you fall under 63A.
No,
63A, which you claim to fall under,
my lord,
has been treated to be a fresh appointment by judicial order. There is no appeal,
my
there is
lord,
no
it
revision.
says, my lord, past service. Past service, my lord, is the contractual service. If I may, my lord,
All right. Yes. Anything more?
Oh, yes, my lord, page, lordship, page 30.
my lord, one more judgment if I may rely, my lord, before my.
You have given a list of books and now you're
No.
giving us more judgments.
No, my lord, it is there in the list
Ah.
of books.
My lord, he was,
Just 1 minute.
This
My lord,
judgment was not there, is it there?
this was not there, my lord. This I just now have taken it out, my lord.
Yes.
Not with regard to the qualifying service, my lord, my humble submission is that, my lord, at paragraph 13 of my writ petition, if I may take, my lord. My lord, one more thing, if I may point out, in the affidavit, my lord, the respondents have not replied to paragraph 11 to, my lord, 16 of my writ petition. There is no reply to those averments. And if I may read paragraph 13, my lord.
You are about to refer to some judgment?
Yes, my lord. Paragraph 13, my lord, before I refer, my lord. That
Paragraph-
minimum qualifying service, my lord, I am fulfilling the minimum qualifying service of 10 years. Paragraph 13, my lord, I have given the two different periods.
No, you are entitled to your claim for pension from the, they are not denying your fresh
My lord.
appointment, the period you have worked.
Yes, my lord, for
fresh
that
appointment.
only, my lord, I am seeking. If that period is earlier period, if it is excluded also, my lord, paragraph 13, if my lord will see.
No.
From 29/6/2006, my lord, I have already completed 13 years, 9 months. More than 10 years, my lord. And my lord, in the judgment which I am referring to, my lord, WPC 1147 of 13. Page 6, my lord. Counsels for the petition, last paragraph I am reading. Counsel for the petitioners have also relied upon the judgment of the division bench of this court dated 28/14, rendered in WA number 289 of 14, wherein the division bench has considered the case of a head constable in the border organization of Assam Police under PIF scheme, who has rendered less than 10 years of qualifying service. The division bench of this court, by the aforesaid judgment, upheld the decision of the single judge bench and dismissed the writ appeal on the ground that the appellant therein did not complete 10 years of qualifying service for being entitled to get compensation. Paragraph 11, 12, and 13 of the judgment are reproduced herein below. Thereafter, my lord, in this instant case, a perusal of para 11 and 12 of the aforesaid judgment shows that the employee of the border organization who has completed 10 years of qualifying service is entitled to get pension as per the rules. In the instant case, all the petitioners, including the husband of the petitioner, has completed 10 years of service before the retirement and death. Thus, they are entitled to get proportionate pension as per para 11 and 12 of the judgment. So, my lord, my claim is also same, my lord. Since I have completed 13 years, post the reinstatement, my lord, that period should be counted for, my lord, grant of pension.
Yes. Mr. Zutia.
yes, my lord, we have also stated in the affidavit, the period with effect from 11/8/2003 to 29/6/2006 is treated as Dice Dawn. Dice Dawn meaning, my lord, Supreme Court says, define the period whether
No,
which
that
is
period you forget it, but what about the period after he was freshly appointed?
fresh appointed.
Ah.
The first appointed, my lord, he will, as per rules, my lord, he will entitled.
But
But
your order doesn't say
past
so.
service cannot be considered.
You forget your past services. But if he's agreeable to grant of pension from the date of fresh appointment.
Well, fresh appointment, my lord, lordship kindly see that there is a page 38 of the writ petition. This is not challenged by the petitioner on 23rd September 2011. This order passed by the governor pursuant to the order of the Supreme Court in the civil appeal 7922/2002. It has been specifically mentioned, my lord,
the PIF personnel would be subject to annual termination and re-employment every year. And Lordship kindly see paragraph 39. If the pension concern require qualifying service in civil appointment for pensioner benefit, their case shall be governed under Rule 176 of the Assam Pension Rules 1969 and not under Rules 173 of the said rules. However, those who are appointed on or after 1/2/2005, their case shall not be governed by the Assam Service Pension Rule 69, but they will be governed by the new defined contribution pension rule 2009. Accordingly,
He was appointed under
he
which date? Reappointed?
2006, 2006.
Fresh appointment.
Fresh appointment. Thereafter, his pension will be governed by the new defined contribution pension scheme 2009. This governor order he has not challenged in this writ petition. And Lordship page 40. Lordship kindly see this is a governor of Assam pleased to order as follows. Number 2, last line. Employees against temporary post co-terminers with the additional PIF scheme of the Government of India. Serial number 5. Ex-servicemen would also be entitled to pension against their service in civil employment, subject to completion of qualifying service as per Rules 176 of the Assam Pension Rules 1969. However, those who are appointed on or after 1/2/2005, their cases shall not be governed by the Pension Rule 69, but they will be governed by the new defined contribution pension rule 2009. Therefore, his fresh appointment 2000 after 2005. So his pension will be governed as per the defined rule 2009. In other service also, my lord. And he has not challenged the court's order. Paragraph 6 and 7 specifically says that his appointment is fresh appointment. So earlier service period cannot be considered. Therefore, my lord, petitioner, if it is entitled for pension, then he is entitled under the new rules 2009.
What do you say regarding the judgments he has pressed into service, especially the judgments of the coordinate bench?
Coordinate bench, my lord, I have not gone through it, my lord. This subject is against the permanent post, my lord. These are the under scheme post. For ex-servicemen.
But he is placed, whether you agree, disagree, distinguish.
No, I am not agreed, my lord.
But without looking into it, how do you disagree?
That is, my lord, I have heard, he says, my lord. My lord, my ear is otherwise not good. And page 67 also, my lordship kindly.
We will continue on Monday.
Again, my lord.
Monday, yes. We are giving you an opportunity to go through the judgment which he has relied on. Try to dispose it of on Monday.
He provided. I will go through it, my lord.
Heard counsel for parties. There has been heard in at length for further hearing on Monday. It is available here. If you want, you can take the list from here also.
No, I will give the copy.
Copy the
I will give.
Please get to item 13.
Yes.
My lord, this is an application for appointment of arbitrator manner under 11(6). Already there is a coordinate bench judgment, my lord.
So first explain to us in short the
Yes.
facts.
The,
There was an agreement. There was
yes, there was a
correct.
agreement, my lord.
Page 23.
Yes, page 23. And relevant portion also I will take 122, my lord.
22.
Yes. 122, the lordship will see clause 55.1 down below, my lord. So, may I read, my lord?
Yes.
Clause 55.1, arbitration and settlement of disputes shall be governed by clause 63.64 of general conditions of contract NF Railway 1998 in edition which are reproduced below subject to any correction made prior to opening of the tender. Now, clause 63 is there, my lord. Matters finally determined by the railway, all disputes and differences of any kind whatsoever asking out for or in connection with the contract, whether during the progress of the work or after its completion, and whether before or after the determination of the contract, shall be referred by the contractor to GM, and the GM shall within 120 days after receipt of the contractor's representation make a notified decisions in all matters referred to by the contractor in writing, provided that matters which may be provisions has been made in clause so and so, so and so. Well, this is the clause. Now, lordship will come to page 123, clause 64.12. The demand for arbitration shall specify the matters which are in question or subject of the dispute or the difference, as also the amount of claim item wise. Only such disputes or differences in respect of which the demand has been made, together with counterclaim set of given railways, shall be referred to the arbitration, and other matters shall not be included in the reference. Now, my claim is at page 236. Now, lordship makes same page, my lord. Down below, lordship will see clause 64(3)(a)(1). So this provides, my lord, if the claim is less than rupees 10 lakh, then there will be sole arbitrator. And clause 64, next page, my lord. It is 10 lakhs or below, my lord, that it will be the sole arbitrator will be appointed. Now, if the claim is more than that, my lord, that is provided under 64(3)(a)(2), the next page 123. May I read, madam?
Your case is here.
Yes, madam. My case is here.
3 arbitrators.
3 arbitrators.
And what is the objection by the respondents?
They are saying, my lord, that the claim is more than 20%, my lord. That's why that is not an arbitrary dispute. My lord, this has already been settled by this court. My lord, your lordship also delivered judgment, my lord. So it is the arbitrator who has to decide it, my lord. And we already nominated one arbitrator, my lord, Padmanabhan, and Honorable Justice Padmanabhan, and they have to nominate one, and both will decide to appoint the third umpire, my lord. So at this stage, my lord, now lordship will see, I'll cutting short, my lord. Lordship see the court-related judgment, which is at page 266, my lord. Same facts, my lord, same contract, same provision, same tender. Already 2 arbitral award has been passed, my lord, and this is the third. This is in respect of claim number 6 and 7, my lord.
17 operative part. 17.
Now, 270 is the operative portion, my lord.
Yes, para 9.
Para 9 will lordship see. May I read para 9 or lordship?
Yes.
Yes.
You can read.
As per clause 64(3)(a)(2) of the GCC, the dispute is required to be adjudicated by a 3-member arbitral tribunal to be headed by a presiding arbitrator. I find from the record that the petitioner has suggested the name of Justice E. Padmanabhan, former judge of Madras High Court, to act as an arbitrator nominated by the contractor. Mr. Gupta, learned CGC, has produced a copy of the communication dated 28/9/21, issued by the Deputy Chief Engineer so-and-so.
What has happened to this order? Is it under appeal? Further
No,
appeal?
no.
Arbitration has progressed.
Yes. So now that just me complete it, my lord. Very short paragraph. So the petitioner company forwarding the names of the 3 nominees of the NF Railway for appointment as arbitrator on behalf of NF Railway. Mr. Gupta submits that any one of them may be appointed as an arbitrator as nominee of the railways. After going through the communication dated 28/9/2021, and based on the submission made by Mr. Gupta, Shri H.K. Gogoi Jaggi, ex-General Manager NF Railway is hereby appointed as arbitrator on being nominated by the NF Railway. Both the arbitrators would now take necessary steps for appointment of umpire and or presiding arbitrator in accordance with the mandate of the Act 1996, so as to constitute the 3-member arbitrator tribunal. So this is the time. And there are other judgments also, my lord. I think my learned friend has.
Yes.
Malab, regarding Malab, the earlier proceeding Malab, where Malab, one arbitrator appointed by the Malab and one by us Malab. This is no denial Malab that is going on Malab. But Malab, and Malab, the railway has agreed to it also Malab. Now Malab, the fact is that Malab, regarding Malab, 20% Malab, the cap of 20% Malab, it cannot exceed more than 20% of the contract Malab. Malab, I'm arguing on that point only, my lord. Now, Lordship, if your Lordship kindly come to page number 305, my lord, of my lord, affidavit, my lord.
No, you show us from the clause very.
Yes, I'm from the clause only, my lord. My lord, the 305, my lord, page number. My lord, clause 55.2, my lord.
305.
305, my lord.
55.2.
2, my lord. In the middle, my lord. Lordship has got it.
No, but from where have you picked up this clause?
My lord, from the contract agreement, my lord.
So come to the contract
My
agreement
lord,
directly.
You
don't have the contract agreement.
My lord, I have my lord, my colleague who is with the file, my lord, he went after finishing his part, my lord, he went. He has contract agreement.
But this is belied by their own letter, my lord. Page 301 may be seen, my lord.
My lord, my lord.
All right, you read from your affidavit.
My lord, I am reading from the affidavit, my lord. It is, my lord, part of the contract agreement, my lord. The provision of clause 63 and 64 of general condition of contract will applicable only for the settlement of claim or dispute between the parties for values less than or equal to 20% of the value of the contract. And when claims of dispute are of value more than 20% of the value of the contract, provision of clause 63 and 64 and other relevant clause of the general condition of contract will not be applicable, and arbitration will not be remedy for settlement of such claim. Now, Lordship may kindly come to 55.
What will be the remedy?
Now, my lord, remedy, my lord, it's my lord, I'll produce some judgment of the Honorable Supreme Court, my lord, where is given, my lord, civil court is the remedy, my lord.
No, under your contract, what is the remedy?
My lord, up to 20%, my lord, arbitration is the remedy, my lord. Beyond that, my lord, he has to go to my lord, civil court, my lord. Now, my lord, kindly come, my lord. The contractor shall not be entitled to ask for reference to arbitration before completion of the work assigned to him under this contract. The contractor shall seek reference to arbitration to settle the dispute only once within the ambit of condition 55.2, my lord. Now, my lord, he has already come, my lord, through my lord, several my lord arbitration petition, my lord, where my lord.
Why the railway did not go in appeal in respect of the earlier order passed?
My lord, what happened in what I was not, my lord, in that my lord case, my lord. The fact remained that, my lord, it was my lord, what I was given to understand, the order was, my lord, that the arbitrator will decide. My lord, the arbitrator will decide the dispute which is before the arbitrator, my lord. And arbitrator, the learned arbitrator holds that since this dispute is within 20%, so this is arbitrable. So, my lord, even my lord, but they have, my lord, crossed that bar, my lord, of 20, limit of 20%, my lord. Already, my lord, 200 crores, 163 crores, my lord. Now again, my lord, they have come with another, my lord. And my lord.
Yes.
And my lord, beyond 25%, my lord, this honorable court has already settled that position, my lord. My lord, I'll, what is one judgment, my lord?
of this honorable court, my lord. My lord. Yeah, this is my lord, arbitration petition 48 of 2023. 48. My lord, para 18, my lord. Judgment copy from. Well, para 18, my lord. Page 9. May I read, my lord? Para 18, my lord. I'm reading.
Yes.
In case of NTPC Limited, Supra, the Supreme Court held that pre-referral jurisdiction of courts under section 11(6) of the Act is very narrow and inheres the two inquiries. The first inquiry is about the existence and validity of an arbitration agreement, which also includes an inquiry as to the parties to the agreement and the applicant's privity to the said application. The secondary inquiry that may arise at the reference stage itself is with respect to the non-arbitrability of dispute. It further
This
held
is
that
an interpretation of NTPC.
yes, my lord.
Where is that judgment?
My lord, I have that judgment also, my lord. My lord, I'll give it, my lord. It is with me, my lord.
All right.
I brought that judgment also.
Yes.
My lord, 19 put also. Para 19. Sorry, 19. 18, sorry, 18. It is further held that as a general rule and principle, the arbitral tribunal is preferred first authority to determine and decide all questions of non-arbitrability. However, as an exception to the rule, the referral court may reject claims which are manifestly ex facie non-arbitrable. The Supreme Court further held that NTPC Limited Supra that the standard of scrutiny to examine the non-arbitrability of claim is only prima facie, and the prima facie scrutiny of the case must lead to a clear conclusion that there is not even a vestige of doubt that the claim is non-arbitrable. The Supreme Court in para 28 held as follows. The para 28, the limited scrutiny through the eye of needles is necessary and compelling. It is intertwined with the duty of the referral court to protect the parties from being forced to arbitrate when the matter is demonstrably not arbitrable. It has been termed as legitimate interference by court to refuse reference in order to prevent wastage of public and private resources. Further, as noted in Vidya Dolia Supra, if this duty within the limited compass is not exercised and the court becomes too reluctant to intervene, it may undermine the effectiveness of both arbitration and the court. Therefore, this court or a high court, as the case may be, while exercising jurisdiction under section 11(6) of the Act, it is not expected to act mechanically merely to deliver a purported dispute raised by an applicant at the doors of the Susan arbitrator, as explained in DLF Home Developer Limited versus Rajapura Homes Private Limited. Para 19. In case of MS BCC Mona Lisa JV, the Delhi High Court had considered a similar provision to clause point number 10.1, that is clause 34 of the special condition of contract SCC. The Delhi High Court held that the petitioner therein had contested that the fact that the aggregate value of the claim exceed 20% of the contract value of the contract work, and the petitioner's only submission was that the arbitral tribunal would determine whether the claim were not arbitrable. The Delhi High Court, on considering the clause 34 of the SCC, which provide for arbitration if the value of the claim was less than or equal to 20% of the contract value, held that the court even within the limited jurisdiction of under section 11 of 1996 Act could conduct a preliminary inquiry to find out if the claims are ex facie arbitrable. It further held that the court is not relegated to a post office to be completely oblivious to the obvious legal infirmities. In the request for appointment of an arbitrator, it is further stated that it is not enough for the petitioner to say that the arbitrator should decide all the jurisdictional issues. The petitioner must cross the minimum threshold that is required in law before the court can act upon the request for appointment of arbitrator. In case of Globe India Enterprise Supra, this court, on considering clause 47 of arbitration agreement, which provide for arbitration in respect of claim of an amount of less than 20% of the contract value, and which provides that arbitration would not be applicable on claims above 20% of the contract value, held that an arbitrator would have to be appointed in terms of the contract agreement, provided that the claim amount was lower to less than 20% of the contract value. As the petitioner therein had volunteered to lower its claim amount to less than 20% of the contract value, as can be seen from the judgment of the Supreme Court, in case of re-interplay between arbitration agreement and under the Arbitration and Conciliation Act 1996 and the Indian Stamp Act 1989, Supra, Section 11(6)(a) of the 1996 Act is still in force. Section 11(6)(a) states as follows: 6(a), the Supreme Court, or as the case may be, the High Court, while considering any application under subsection 4 of subsection 5 or subsection 6, shall, notwithstanding any judgment, decree, or order of any court, confine the examination of the existence of an arbitration agreement. The Supreme Court in the above case has not gone into the question as to whether the High Court can make a secondary inquiry with respect to non-arbitrability of the dispute after having made the preliminary inquiry with regard to the validity and arbitration clause in the contract agreement. The law has been clearly settled by the judgment of the Supreme Court in NTPC Limited Supra, where it has held that the referral court may reject a claim which is manifestly and ex facie non-arbitrable. In the present case, there is no dispute with the fact that petitioner had made a claim that is beyond the initial contract value, and as such, on a prima facie scrutiny of facts, this court find that the petitioner has not been able to cross the minimum threshold that is required for deciding the dispute between the parties by way of arbitration. In terms of clause 10.1, to appoint an arbitrator, even though there is no doubt in view of the court that the present dispute is not arbitrable, would lead to wastage of resources, besides being a sheer waste of time. In view of clause 10.1 of the contract agreement, having barred the resolution of the dispute between the parties through arbitration, the present petition dismissed, the parties are free to avail other judicial remedies for adjudication of the dispute. The petition accordingly dismissed, my lord. And my lord, this is not only the single case, my lord. There are other 2 cases, my lord, where same view has been taken, my lord. In fact, my lord, 3 cases, my lord. My lord, I am giving, my lord, all 3 judgment, my lord, including, my lord, the judgment in, my lord, the Supreme Court, which, my lord, relied upon in the present case, my lord.
There are subsequent judgments.
Yes.
To the judgment
Yes.
that you have referred to as NTPC.
I will produce one judgment of Supreme Court, my lord.
We have the judgment. You give us a list. Why do you give us the printout? We can take
My
it.
lord, my humble submission is, my lord, since, my lord, they have already crossed the 20%, my lord. It is not that, my lord, here in
You are making your submission on the basis of a
Yes, sir.
judgment which has been partly overruled. Would you not like to apprise yourself with the
Yes,
latest?
my lord, my lord, I do not have that judgment, my lord. Lordship, my lord.
Don't make submissions on the basis of law which has been watered down, at least, if not overruled.
So, my lord, my humble submission is that, my lord, the contract agreement is clear, my lord.
Your submission is based on a judgment where subsequently the same apex court has differed with the judgment. You need to address the court on this.
My lord, today, my lord, I do not have that judgment, my lord.
So get your judgments, come back properly apprised.
My lord. My lord, any day, my lord, convenient to lordship, my lord. 1 or 2 days, my lord, I'll.
Monday?
Monday, my lord.
Yes.
Monday.
Matter stands deferred on the request made by the council for the respondents. Place later that means before the court.
My lord, may I get that case law, my lord, which is just given to my plan, but that case law, my lord. just-
Which case law?
Now, one case law given, which.
He has not given us any case. law.
My-
We can't provide you assistance.
No, no, my lord,
Provide-
no, I thought, my lord, he given some, my lord, judgment against, which is against me, my lord. That is.
Given, to find out from you. Monday.
আপোনালোকে মোক নিদিওঁ, মই কাৰ পৰা দিম? আপুনি সেইটো কপিটো দিয়ক। You give me that copy. You are lying. You are not giving me, how can I give you?
नहीं itu ना hello
Huh?
Ablash man.
Yes. Yes, Mr. Nath. There is an office memorandum which has been placed before the court. And on the basis of which they're seeking a review. Now, is this office memorandum still in force?
Lordship, the office memorandum, it is of,
That's page number 110 or 11, whatever it was. 111 in the review.
25. Yes.
25 May, yes.
Yes, 25 May 2016. Yes.
Now then the government has already taken a call not to hold interviews.
No, Malad, this Malad, on last occasion I submitted, if Lordship may kindly see the second and third para, Malad, the here, Malad, what has been said, the Honorable Chief Minister of Assam has directed that the system of holding interview for recruitment of such grade 3 and grade 4 posts where personality assessment is not an absolute requirement will be discontinued with immediate effect. You are therefore requested, all the additional chief secretary, all the departmental authorities were requested to examine the matter in respect of all establishment under your administrative control and make necessary amendment to the respective service rules, executive instructions wherever required to discontinue the process of interview for recruitment of grade 3 and grade 4 post. So a request was made and the necessary amendment will be brought in the recruitment rule. That is a separate aspect, Malad, altogether. Here the review has been sought. Lordship has seen the judgment. But what has happened here? A process was initiated, and on last occasion, Malad, the extract of the cabinet, I have placed it before your Lordship. The decision was that the just. Well, I'm just pressing that. Kindly give me a minute, Madam. Well, the extract of the minutes of the cabinet meeting held on 9/10/2018. In fact, referring to this particular cabinet memorandum, the cabinet decision, the review has been filed. They said that the digital viva has been approved. This was not placed while deciding the writ petition, therefore review. Here, kindly see the decision taken by the cabinet is.
You are referring to?
The extract of the minutes of the cabinet meeting held on 9/10/2018. On last occasion, Malad, on last date, I have placed a copy, Malad.
What is the date?
It is 9/10/2018. Possibly third page, Malad. Copy copy as an error.
Yes, 9/10/2018.
Yes, Malad.
Yes.
This Malad minutes of the cabinet meeting, the cabinet has taken a decision. One is, Malad, each department will write up to the state level police recruitment board
giving details of grade 3 and grade 4 backlog vacancies reserved for persons with disabilities. The department will also give details of educational qualification for this post prescribed under their respective service rules. The state level police recruitment board will conduct a common test for grade 3 and a common test for grade 4 as far as possible. So these are the decisions taken by the cabinet. There is no decision approving or suggesting for digital viva. Here the issue now taken up by the petitioner is the digital viva.
When was the decision taken to abandon this digital viva?
In
Also by
fact,
cabinet.
in fact, no. In fact, there was no decision. If Lordship kindly comes to the order which is under review, my lord, that my lord,
No, we will come to that. What we want to know is even in your cabinet decision,
my lord,
you have taken a decision that grade 3, grade 4,
entrusting the state level police
state
recruitment
level
board
police.
to hold the election, to hold this election.
So the cabinet decision is to give the state level police recruitment board. Now pursuant to that, something happened and it was abandoned and given to Guwahati University.
Process was cancelled and accordingly it was given to Guwahati
But
University.
this page number 111,
My lord,
which is 25.5,
Lordship.
there it shows that the system of holding interviews for recruitment of grade 3 grade where personality assessment is not required will be discontinued.
Will be, my lord. And necessary after making necessary.
This is prior to your cabinet decision.
True.
So what is the status now? If it is to be, if there is a policy decision to say that it shall be discontinued, it has to be discontinued.
But until and unless, my lord, therefore, the third paragraph says that necessary amendment in the rules has to be made. Wherever, my lord, it has been made, possibly they have done it.
Towards the rules.
No, rules, my lord, in respect of all the departments.
Whatever departments, give us an instance of the rules, some rules. Which department is it?
Look, this was nowadays, this is conducted by the Social Justice and Empowerment Department. And
these recruitments arise in various departments.
all departments.
Only the social justice is the nodal department.
For persons with disabilities, they are the nodal.
So your review petitioners were applying for
Grade 4.
which department?
So department, no specific department.
Okay. So show us any of the rules that.
But for the purpose of this review, just kindly allow me to place, paragraph 3 of the order, which the review has been prayed for. In fact, the process was cancelled and that was challenged before your lordship. Now, kindly come to para 3 of the judgment. This is their basic grievance. After the said advertisement was issued, several physically challenged persons of the state applied for the post, including the petitioners, and for conducting recruitment examination, the state level police recruitment board was entrusted. After all necessary formalities were completed, examination was conducted by the police recruitment board. And in the case of grade 4 post, the examination was conducted through digital viva. And when the interview board had completed about 5 to 6 districts, there were complaints about the manner in which the examination was conducted. Therefore, the state level police recruitment board, through a press note dated 9/10/2020, kept on hold the recruitment process with effect from 10/10/2020. Thereafter, by a notification dated 31/2021, issued by the Principal Secretary to the Government of Assam, Social Welfare Department cancelled all the digital viva interview conducted by the state level police recruitment board for the 7 districts, and at the same time announced that the recruitment process would be carried out by the Guwahati University by utilizing the application form already collected by the state level police recruitment board. Being agreed by the said notification and the mode of recruitment process adopted by the university, which is not done through the digital viva interview, the petitioners are before this court praying for issuance of appropriate writ or order or direction directing the respondents not to cancel the digital viva interview already completed, and also to direct the respondents to continue with the interview through digital viva and interview. But this decision was challenged by them, and finally, Lordship, paragraph 9 and 10, Lordship has dismissed the writ petition. Now, in paragraph 21 of the writ petition, the review petition, they said that these are the two documents. One is my lord, the extract of the cabinet meeting, which has, according to them, approved the digital Viva mode. And second one is the 25 May 2016. These are the two documents. Those were not placed before the Honorable Court at the time of considering the writ petition. Had this been placed, the outcome would have been different. My respectful submission is, my lord, digital Viva is a mode. My lord, paragraph 9, Honorable Court has said that it was the state level police recruitment board has engaged a third party to conduct the examination, and they have adopted a mechanism, my lord, for digital Viva. It was not approved or nothing, my lord, no record is there. Therefore, it was cancelled, and now they said that it is as per the cabinet memorandum. Cabinet memorandum I have placed, there is nothing. My submission is, my lord, even if the cabinet memorandum is placed with your lordship, it doesn't, my lord, make any change, my lord. It doesn't make any difference what they have now sought to project. Therefore, the review petition, my lord, is not maintainable, my lord. Kindly come to para 21 of the review petition. That is what they have
Scope
projected.
of review is very limited.
The review scope of it is.
You urge all this in the appellate court forum.
And in fact, these documents doesn't have them. What they have projected.
See,
doesn't have.
even if we recall it on the basis of these memorandums, ipso facto, it does not substantiate your case to say that the authority, the government was not authorized to conduct the interviews. You are trying to project that there was a policy decision taken not to conduct interview. Whether this decision is implementable, not implementable, acceptable, not acceptable will require interpretation. How does this particular document affect the judgment which has been delivered, to the extent that had these documents been before the court could not have, on the face of it, come to this conclusion. It will require an interpretation whether these decisions taken will restrain the government from going forward with the interview. It requires an interpretation. Yes. Had it been a case that the court had given a finding that there is no policy, is there any finding in the order that no policy decision to the effect has been taken place by the government? There's no finding. Then it would have been a clear case for a review.
State level police recruitment board adopted the digital Viva in compliance with, if your lordship see the paragraph, page 37 of my review.
Mr. Counsel, you may urge anything before the appellate court. The review is only to bring on record that this judgment suffers from an error apparent on the face. That some document was wrongly interpreted.
Yes,
or some document the court has proceeded on court has proceeded to hold something which is contrary to the documents which you have now found out.
That is true, my lord. But even after, my lord, due diligence, my lord, these two documents, this particular notification and my lord, office memorandum dated 26/2/2013, my lord, page 37 of my review petition, my lord, what is the procedure to be adopted for a, my lord, disabled person?
You are entitled to put into challenge the judgment of the coordinate bench in appeal. You may urge your case that the conclusions arrived at on these are incorrect, etc., not found, not justified. But now you are asking for review to recall the judgment.
Because, my lord, those, my lord, pleas were not taken in the writ petition.
That's right. So even if these pleas were taken, does it make the judgment defective on the face of it? No. It will require interpretation. Whether these documents actually denude the government of the power to go for interview. Plain reading of these documents does not.
Or what has already my senior friend already, my lord, done.
Heard, counsel for the parties, it's review petition is directed against the judgment and order dated 3/3/2021, passed in WPC number 1049 of 2021 and other connected writ petitions. Stop. The petitioners are physically challenged persons who applied for grade 4 posts in response to the advertisement dated 30/12/2018. Issued by the Chairman, State Level Police Recruitment Board, Assam. Which was conducting the recruitment process for grade 3 and grade 4 posts in various departments of the state government. Stop. The said advertisement was issued by the government for filling up backlog vacancies reserved for physically challenged persons. Stop. Pursuant to completion of the formalities, the examination was conducted by the Police Recruitment Board, and in case of grade 4 posts, the selection was conducted through digital Viva test. Stop. This test of the selection process undertaken by the state level police recruitment board had completed the selection in respect of 5 or 6 districts of the state of Assam. Stop. Subsequent thereto, several complaints were raised about the manner in which the examination was conducted. So, thereafter, the state level police recruitment board, through a press note dated 9/10/2020, kept on hold the recruitment process with effect from 10/10/2020. Stop. Subsequently, by notification dated 30/01/2021, issued by the Principal Secretary to the Government of Assam, Social Welfare Department, all the digital Viva interview conducted by the state level police recruitment board for the 7 districts was cancelled. Stop. It was also announced that the state recruitment process will be carried out by the Guwahati University by utilizing the forms, application forms already collected by the state level police recruitment board. Stop. The review petitioners as writ petitioners challenged this notification, cancelling the selection recruitment process undertaken by the state level police recruitment board and the selection sought to be undertaken again by the Guwahati University was put to challenge by the present writ petitions being WPC number so and so, so and so. So the matter was contested by the respondents, and by judgment and order dated under review dated so and so, the writ petitions came to be rejected. Stop. Para. The review petition thereafter has been directed against the judgment dated so and so, passed in WPC so and so, on the ground that in spite of due diligence, the review petitioners could not place before the court 2 office memorandums, being office memorandum dated 13th of April 2017 and the OM/notification dated 25th of May 2016, I want to do office memorandum dated 13 April, so and so, issued by the Government of India, Ministry of Personnel, Public Grievances and Pension, Department of Personnel and Training, and the notification dated 25th of May 2016, issued by the Secretary to the Government of Assam, Personnel Department. Better. Learned Senior Counsel appearing for the review petitioners strenuously urges before the court that these two, that this office memorandum and the notification or communication, one issued by the central government and the other by the state government, clearly reflects the intention and the decision taken by the government at the appropriate level that for grade 3 and grade 4 posts, where personality assessment is not an absolute recruitment, recruitment by the system of holding interviews will be discontinued with immediate effect. Stop. It is therefore submitted by the Learned Senior Counsel that had these documents been placed before the Learned Single Judge, the judgment under review could not have been rendered, as the government has already taken a decision to do away with the process of recruitment for grade 4 posts by way of interview. Stop. The further submission of the Learned Senior Counsel before this court is that the manner in which the state level police recruitment board undertook the selection process by way of digital viva was more objective, as the candidates were required to make their choices on the basis of the questions which are presented before them in the process of digital viva. Stop. However, let's stop. There was no written examination. Stop. However, the process of digital viva required the candidates to answer to select the correct answer to the questions which are reflected or which are presented to them by the process of digital viva. Stop. The Learned Senior Counsel further submits that the cancellation of the process of recruitment by digital viva undertaken by the state level police recruitment board and replaced by the interview now sought to be undertaken by the Guwahati University will greatly hamper the prospects of all legitimate candidates, as there is a scope of as if the selection is restricted only to personal interviews without there being any written examination, it gives scope for arbitrariness and as the selection of the candidates will depend on the assessments, subjective assessments made by the interviewers. Stop. Therefore, the process of selection by way of interview as sought to be made by the Guwahati University will not being objective does not fulfill the purpose for which this special drive for recruitment of these are persons with disability.
Yes.
For persons with disability has been sought to be achieved. So there are several candidates who may have hearing or speech disability, and therefore the very process of undertaking the selection by way of only interviews is contrary to the objective sought to be achieved. Better. It is therefore submitted that the judgment under review was rendered without taking into consideration the OM and the notification enclosed to the present review petition. And therefore, these OM and the notification was a relevant material that ought to have been placed before the court by the respondents, and its existence was not known to the review petitioners in spite of due diligence. Stop. Now, subsequently, this information has come to their knowledge, and therefore, the present review petition is filed seeking the review of this judgment and order dated so and so. Well, Mr. D. Nath, learned senior government advocate, on the other hand, disputes the submissions made by the learned senior counsel. Stop. Mr. Nath submits that although the notification dated 25th of May 2016 refers to discontinuation of interview in respect of grade 3 and grade 4 posts where personality assessment is not an absolute recruitment. This is subject to such changes or amendments being brought to the service rules / the executive instructions which were required to be undertaken. Stop. It is submitted that such changes have not yet been undertaken, and therefore this notification even if had been considered by the Bonet bench would not have altered the outcome of the judgment. So during the course of the hearing, a reference was made to a decision taken in the state cabinet regarding the conduct of special recruitment drive for filling up of backlog vacancies in grade 3 and grade 4 post for persons with disabilities within bracket PWD in various departments. So
If I may just submit, Bharat. But they have taken a ground that the state cabinet has approved digital Viva. And in that, by that particular minors, that I have placed that there is no such approval. That is their basic ground. Bharat.
it was pointed out by the senior counsel preparing for the review petition that in the minutes that the state cabinet had taken a specific decision to proceed for the special recruitment drive to be undertaken, has taken a decision that the selection and recruitment for the under the special recruitment drive will be undertaken by digital viva only. Stop. As a consequence thereof, the senior government advocate was directed to place before the court the materials, if any, as to whether such a decision was taken by the state cabinet. Stop. The senior government advocate has placed before the court an extract of the minutes of the cabinet meeting held on 9/10/2018, which does not reflect that any such decision was taken by the state cabinet, that the recruitment undertaken by the state police recruitment board for the special recruitment drive, will be undertaken only by means of digital viva. Stop. The minutes does reflect that decision was taken, that the state level police recruitment board will conduct a common test for grade 3 and a common test for grade 4 as far as possible. Stop. However, subsequently, in view of the complaints received, the state police recruitment board had kept the recruitment process on hold. Thereafter, by notification dated so and so, the entire selection process was cancelled. Well, time and again, the parameters for review of a judgment has been laid by this court as well as by the apex court. Stop. The parameters which are in which a court exercises or invokes its review jurisdiction are in the spirit of the provisions of the CPC. Stop. Ordinarily, it is an error apparent on the face of the record. Stop. Or such other material which was very relevant for the purposes of deciding the issue, which could not be placed before the court, and which had it been placed before the court would have altered the decision arrived at by the court. Stop. A reference in this case, reference in this regard can be made to the judgment of the apex court rendered in so and so versus so and so, reported in so and so. Well, coming to the facts of this case, the core issue is whether the decision to cancel the selection undertaken by the state level police recruitment board and to carry on the recruitment by giving the responsibility to the Guwahati University by way of interviews was the issue essayed before this court. Even if the notification dated so and so and the OM dated so and so which has now been placed before the court by the review petitioners, as also the extract of the extract of the decision taken by the state cabinet on Nine 2018 in this regard is perused. In the opinion of the court, it does not render the judgment under review defective. Stop. This court does not find any error which persuades this court to invoke its review jurisdiction. Stop. The question of whether the process of this process of recruitment to be undertaken by way of interview by the Guwahati University and the correctness thereof is an issue which has been decided by the coordinate bench. If the petitioners are aggrieved, they have a remedy of inter-court appeal. Stop. In review jurisdiction, the court is not required to give a further opportunity of arguments to the review petitioners, as it will amount to redeciding the matter in the garb of rehearing the matter in the garb of the review. Stop. There being no merit in the review petition, the same therefore stands dismissed.
Item number 3 is a writ petition, my lord. So.
Writ petition for what?
Writ petition also, my lord, some other my lord, candidates, they have just challenged the, my lord, the rejection of the digital viva.
This is covered by these judgments under review.
Lordship has considered the limited jurisdiction of the review.
All right. The writ petitions be segregated and listed separately after review. Both, there are two reviews.
Yes, ma'am.
There are two.
Two
One
reviews
and-
dismissed. Item given. 1, 2, and 3.
Highly applicable.
I was for respondent number 4 and 5.
Mr. R.M. Das appears for respondent number 4 and 5, that is
Social justice.
social justice. Anyone else?
Respondent number 3, Lordship.
Who is respondent 3?
Guwahati University.
Guwahati University. Mr. So-and-so appears for Guwahati University. Yes.
Pending item 14.
Yes.
Lordship, in this matter, I am seeking for some time, Lordship, as the private respondent has filed an affidavit, which is not in my record, Lordship. May I please a copy of the affidavit so that I can.
I'll provide you.
Mr. R.M. Das, Council for
Water Resources.
Water Resources, submits that he has not been served with a copy of the reply.
Affidavit filed by the private respondent.
Affidavit in opposition filed by the private respondent. The counsel for the private respondent will furnish. You are for the private respondent?
Yes, ma'am.
Furnish him a copy. Furnish a copy of the affidavit filed, enabling Mr. Das to peruse the same. Matter stands deferred to be listed in the month of January
January, my lord, there's an interim operation.
or February.
January.
Be listed on 21st of January.
My lordship.
Interim order passed early will continue.
Lordship.
Obviously.
Item 23.
May I please your lordship? Matter relates to reduction of pay of the petitioner on the last month of his service, lordship. He retired on superannuation on 30/09 to 2021. And Lordship will see his pay in the month of July and August 21, which is at page 81 and 82. 81 is the pay slip for the month of July 21. His basic pay, the second table below, second column, third row, basic pay 79490. This is pay slip for the month of July 21. Then August 21, Lordship will see basic pay 79490. 79490. But Lordship, next page Lordship will see 83, page 83. This is the last month of his service, September. On 17/9/2021, they have done a calculation and refixed his pay with effect from 1/4/2017. Here, Lordship will see the 9th column, Lordship, the last column, 1/7/2021. Here, his basic pay has become 75,100. So, by about 4,000 rupees has been reduced in the last month of his service. Now, he had pursued the matter in the office and they have issued him a letter at page 88. Thereafter, he submitted representation. They kept on rejecting it by issuing separate orders, which are impugned in this particular writ petition. Now, before going into the impugn orders, rejection orders, I would like to place my Lordship service particulars from the very beginning, Lordship. He was initially appointed as Lordship Peon on 1/7/1980. 1/7/1980. Then he was promoted to senior peon on 1/7/1987. And on promotion, he got a promotional increment. Then, Lordship, he was granted fresh appointment as typist. This is at page 30. Page 30. On 13/10/1988. Now, I am saying this is a fresh appointment, whereas they are saying, Lordship, this is not a fresh appointment, it is a promotion. This is a promotion. Lordship, what is the effect of the fresh appointment and how it will affect my entire case, Lordship? That I'll come to later on. First, let me kindly allow me to place the entire particulars, Lordship. I was freshly appointed as typist, page 30, 13/10/1988. Then, Lordship, then came the fixed pay commission, Lordship, 1/4/1997. Fifth pay commission, and my pay was fixed in the fifth pay commission.
What is your name here in page number 30?
30 Luku Kolita, serial number 2.
Okay.
I'll come to this aspect, Lordship, that this is a fresh appointment, Lordship, later on. Then, Lordship, then came, Lordship, fifth pay commission. Fifth pay commission, it was given effect to from 1/4/1997. And they have given me the corresponding pay in the fifth pay commission with effect from 1/4/1997. That is not disputed and that is seen from page 88, impugn order. That can be seen, Lordship, from page 88. Page 88, they have given a table refixing my pay.
Where is your order for promotion to senior typist?
Senior typist, I never became, Lordship.
No, you said typist. No, sorry.
I was appointed as peon.
Peon.
Then senior peon.
Senior peon. Okay.
Senior peon.
Where is senior peon order?
Senior peon order I don't have, but it is reflected in their order only. Page 88, Lordship will see. 88.
88.
88, serial number 1, Lordship will see. After checking of time to time pay fixation of the incumbent, it is observed that incumbent was promoted to the post of senior peon on 1/7/1987. After senior peon, fresh appointment as typist. Page 30 I have shown. Then came the fifth pay commission, revised pay. This also, Lordship will see at page 88. Page 88, the table below, against the date 1/4/1997, Lordship will see 1/4/1997, 5075 ROP 1997. They have given me corresponding pay in the fifth pay commission structure. So thereafter, thereafter came the financial upgradation scheme under OM dated 30/12/2006. This scheme has been enclosed by the respondents themselves in their reply at page 116. Page 116. Now here, 116, Lordship.
Yes.
I'm reading Lordship serial number 1. The benefit under the scheme shall be admissible with effect from 1/7/2007, 1st January 2007. Then under para 2, para 3 I am reading, Lordship. The benefit of 2 financial upgradation under the scheme shall be given by upgradation of the pay scale of the next higher promotion grade post relevant to an employee in accordance with the existing hierarchy in a cadre/category of post. Then serial number 4A. The benefit of first financial upgradation will be admissible to an employee on completion of 10 years of regular satisfactory service, and second upgradation will be admissible after 15 years of regular service from the date of first upgradation. Then para 5, Lordship will see. Para 5. In accordance with the norms laid down in para 4 above, an employee completing as on 1/1/2007 10 years or more but less than 25 years of service shall be fitted in the pay scale of the first next higher promotion grade post in the service to which the employee belongs. Meaning thereby, if I have completed more than 10 years and less than 25 years on 1/1/2007, then I will be entitled to 1 upgradation on 1/1/2007. And accordingly, I was granted this financial upgradation on 1/1/2007 that they have mentioned at page 88 also. I'm repeating, Lordship. According to this financial upgradation scheme, Lordship, first financial upgradation is granted on 10 years. Second is granted.
When were you promoted as senior peon?
Senior peon
After
on
how many years?
after 7 years.
So first upgradation you received that as a senior peon.
First promotion.
No. First promotion. I'm
Promotion.
talking about the
This is only financial upgradation.
financial upgradation.
Yes.
That's right.
Now, here comes, Lordship, why I am saying my appointment as typist is fresh appointment. My appointment as typist is on 13/10/1980.
Is it pursuant to a recruitment undertaken?
Yes. Lordship will see
Elected-
page 30. Page 30. Page 30. This is the order.
No, forget the order. Was it pursuant to an advertisement,
Yes.
selection?
Because it contains persons who are outside the department also. Serial number, Lordship will see page 30.
No. For you to be appointed, you are already a part of the department.
Yes.
For you to be appointed again,
Yes.
you must apply.
I applied.
You applied.
I applied.
Where are these applications and pursuant to what advertisement?
Lordship, advertisement is right now not available.
No, but you must have applied.
I have applied. Here I have stated, Lordship. Here Lordship will see order at page 30. Subject to satisfactory police verification and on character and antecedents and submission of medical fitness certificate. These are not elements of promotion, Lordship. If I am already an employee of the department,
Yes.
then these are not to be sought from me. And this is a common order issued in respect of all. So when
out of these 5 persons besides you,
yes,
they're all fresh appointees. They were not employees under the board.
serial number 1, 3 and 4 are outsiders. They are outsiders. Then Lordship will see nowhere it is written promotion. Nowhere it is written promotion. Then I have stated police verification, character, antecedents.
No, all this I have understood, but you will have to apply if it is a fresh
I
appointment.
have applied, Lordship. I have applied and
Where are these
freshly.
applications? There must be an advertisement. You will have to apply.
Yes, there is a selection test also that I have enclosed in my reply. Reply, page 134, Lordship will see. Affidavit in reply, page 134. 134. This matter is of 1988, Lordship. Selection test for recruitment as typist. What is this recruitment? And please appear on a selection test for appointment as typist on 18 to 1988. 1988 matter, 1988. No TADA will be admissible. If it is a departmental promotion, definitely I would have got TADA, Lordship. Then, Lordship, it is very clear from the order itself, page 30 order itself, that it is a promotion. Next page, Lordship, will see page 31. For the outsiders, department is seeking for medical fitness certificate. Lordship, will see page 31.
31.
For a moment, Lordship will kindly have a look at the original order and not the typed one, Lordship. Original is at page 33, relevant 34, Lordship will see. In respect of serial number 7 and 8, 6, 7 and 8, who are outsiders, department has sought for medical certificate. Has your Lordship got, Lordship, page 33 below, serial number 6, Sanoitko Boro. He is outsider. Serial number 7, Babula Das, Sondro Das, Rekharani Das. They are advised to so-and-so medical fitness certificate from board's authority practitioner at the time of joining. They are also to report for duty within so-and-so days from the date of the issue of this order. But in respect of Luku Kolita and Komal Sondro Deka, who are existing employees, this condition is not there. Because they are existing employees. So my contention is that it consists of employees, both outsiders and insiders. They have applied afresh for fresh appointment. So this is a fresh appointment. Then again, Lordship will see, it mentions, last line, Lordship will see page 30, appointment is purely temporarily and their service are liable to be terminated at any time without notice and without assigning any reason thereof. This is not contained in a promotional order, Lordship. For a fresh appointee, such conditions can be expected to be seen. So it is a fresh appointment. So if it is a fresh appointment, Lordship will again come to the financial upgradation scheme, which is enclosed at page 116 of their reply. 116.
Yes.
Relevant 117. 117, para 5A. 5A. In accordance with the norms laid down in para 4 above, an employee completing as on 1/1/2007, 10 years or more, but less than 25 years of service shall be fitted in the pay scale of the first next higher promotion grade post in the service to which the employee belongs. Meaning thereby, Lordship, if I have completed 10 years from the date of my appointment and less than 25 years, then as on 1/1/2007, I will be getting one financial upgradation. So this is the purport, and accordingly I was granted also. Page 88 again, Lordship will see. Page 88. Now they are saying that that financial upgradation which was granted to me on 1/1/2007, that is irregular. Now again, Lordship will for a moment.
This financial upgradation is granted when?
When he is stagnated in a particular post.
Exactly. And according to you, you have joined fresh appointment.
Fresh appointment. From the date of fresh appointment, I have stagnated from 1988 till 2007. So it is a long stagnation, Lordship. From 1988. Near about 25 years. Less than 25 years, but much more than 10 years. That is what para 5A says. If he has been in a particular post for more than 10 years, but less than 25 years, then he will get one financial upgradation on 1/1/2007. Long stagnation. Then for a moment, for a moment, Lordship can even see para 5B, page 117. What if I have completed 25 years? In accordance with the norms laid down in para 4, an employee completing as on 1/1/2007, 25 years or more of service shall be fitted directly in the pay scale of the second higher promotion in the service to which the employee belongs. If it is 25 years, then second. I have completed only 10 years, less than 25 years, so I am covered under 5A, and I have been granted on 1/1/2007 a financial upgradation. The fact that I was granted on 1/1/2007, that your lordship will get at page 88. Page 88. Now they are saying this is irregular. Page 88, again I am reading para 1. After checking of time to time pay fixation of the incumbent, it is observed that the incumbent was promoted to the post of senior peon on 1/7/1987.
What is the meaning of, we come to page number 116, clause 2. Clause 2. What is the primary post of the cadre? That is the feeder cadre. First appointment.
Under the scheme, such of the employees who, after initial regular appointment in a primary post in an isolated post, becoming otherwise. Oh, lordship, if it is not applicable in my case, it is in case of a ex-cadre post where there is no promotional scope. Where there is only one post in a particular cadre. Their lordship, these cases of promotion and all will not be relevant. He will anyway be stagnating in that particular ex-cadre post. This is not relevant to my case, lordship. It is also said as an isolated post. Now,
It is not ex-cadre because isolated post on a direct recruitment, and then you find you otherwise become eligible for normal promotion. So it can be an isolated or can be an ex-cadre post. Anyway, carry on.
Page 88, lordship will say, I was granted this benefit financial upgradation on 1/1/2007.
All right. We have understood that. Yes. Respondent, what do you say?
Then other things. Actually, what has happened, lordship? 3 things have been taken away from my pay. First of all, lordship, this financial upgradation benefit on 1/1/2007, this has been taken away from me, which was originally granted. It has been taken away from me that your lordship can get at page 89. Then, lordship, another benefit has been taken away. My 3 promotional increments, which were initially granted to me on my subsequent promotion to the post of junior assistant, senior assistant, and superintendent. For that, they have taken the ground that these are not having, I have not nothing to do with discharging of higher duties and responsibilities. They say that these do not accompany discharging of higher duties and responsibilities. So these promotional increments have been taken away. But lordship, these promotional increment, along with the annual increment, is granted to a person in terms of the ROP rules of 2010 and 2017. These are mandate of rules, statutory rules. So I was granted this benefit in accordance with rule, lordship. Para 10(1)(I) of ROP rule 2010, I can show, lordship. I can show these things. Lordship will have a look at my next promotion. Next promotion to junior assistant, page 55. Page 55. I was promoted to junior assistant by this order at page 55, 15/5/2009. So, as per ROP rules 2010, I have enclosed the ROP rules, page 39, lordship will see. 39. Page 39, lordship may kindly come. Relevant portion, page 45. It is with effect from 1/1/2006, para 1, subclause 2. Then page 44, Lordship will see 44. 44. Subpara 44, rate of increment in the revised pay structure. Subpara, Lordship.
Let us hear the respondent, or we'll come back to you. Yes.
Our stand will be evident from page 93, madam. We are relying on FR 22. In fact, Lordship, at the occasion of hearing this matter on an earlier occasion, madam, we are relying on FR 22, my lord. Our stand is that the post to which he was promoted does not involve any responsibilities or duties of greater importance. And that is why the grant of increment was not proper.
FR 22 is perhaps with regard to additional charge.
Well, that FR 22, in fact, on the last occasion, my lord, there was a confusion because this has been amended. My lord, I had given a book, my lord, list of books, 2009 3 SCC. There, the FR 22, amended FR 22 has been quoted, my lord.
It was deleted with effect from 1189.
Yes, ma'am.
Now, when was the impugned order passed?
No, fixation has been done in 2000, later on after his retirement. But he was given the increment, first increment was given in 88, 1988.
It is prior to.
Second increment on his promotion on 13/10/1988. In fact, 22, Lord, if your lordship kindly takes up the judgment, my lord, put the.
Was he promoted or appointed?
My lord, our stand is that he was promoted.
So if it is promoted, then how is FR 22 attracted?
It'll be attracted, my lord. Prior date, it was FR 22C, my lord.
Yes.
If your lordship is taking up the judgment, my lord, it is at paragraph 37, my lord, 22C is quoted. Notwithstanding anything contained, lordship has got it.
These are Assam rules.
No, my lord.
Then?
This is the fundamental rule 22, my lord.
Central.
Central.
Is it parameter with the Assam rules?
Yes, same. The initial pay of the government is appointed to post is same.
Paragraph? Which paragraph?
Paragraph 37 and 38. Excellent, like it's true.
Hmm.
22C as the unamended portion was, my lord, notwithstanding anything contained in these rules where a government servant holding a post in a substantive temporary or officiating capacity is promoted or appointed in a substantive temporary or officiating capacity to another post, duties and responsibilities of greater importance then those attaching to the post held by him, his initial pay in the time scale of the higher post shall be fixed at the stage next above the pay notionally arrived at by increasing his pay in respect of the lower post by one increment at the stage at which pay has accrued. Now this is amended, my lord, para 38. I'm reading the clause, my lord. 22(1). The initial pay of the government servant who is appointed to a post on a time scale of pay is regulated as follows. A1, where a government servant holding a post other than a tenure post in a substantive or temporary or officiating capacity is promoted or appointed in a substantive, temporary or officiating capacity, as the case may be, subject to the fulfillment of the eligibility conditions as prescribed in the relevant recruitment rules, to another post carrying duties and responsibilities of greater importance than those attaching to the post held by him, his initial pay in the time scale of the higher post shall be fixed at the stage next above the notional pay, arrived at by increasing his pay in respect of the lower post held by him, regularly by an increment at the stage at which such pay was accrued, or rupees 100 only, whichever is more. Number 2, when the appointment to the new post does not involve such assumption of duties and responsibilities of greater importance, he shall draw as initial pay the stage of the time scale which is equal to his pay in respect of the old post held by him on regular basis. Or if there is no such stage, the stage next above his pay in respect of the old post held by him on regular basis. This is what is being relied on. Para 41, my lord.
So this is what I'm saying. This is on temporary or officiating promotion.
No, not just that, my lord.
It is.
No, my lord. When a government servant holding a post other than a tenure post in a substantive or temporary or officiating capacity is promoted or appointed in a substantive, temporary or officiating.
Right.
All three, my lord. Whether it is substantive, temporary or officiating, all three.
No, see, you are reading only the first part. It
Yes.
has to be read with the second part. He is promoted, the first part is relating to a person, relates to the post from where he is promoted. And then is promoted to another post carrying duties, responsibilities of greater importance.
Exactly, my lord. So let us read again, my lord. Where a government servant holding a post other than a tenure post in a substantive or temporary or officiating capacity is promoted or appointed in a substantive, temporary or officiating capacity, as the case may be, subject to the fulfillment of the eligibility conditions as prescribed in the relevant recruitment rules, to another post carrying duties and responsibilities of greater importance. So he is promoted to another post.
Right.
So that is what our stand is, man. That the post to which he was promoted does not involve the responsibilities, the duties and responsibilities of greater importance.
How do you, who decides on that?
That the employer will have
How
to
can
decide.
they decide on this?
Going by the duties, my lord, the nature of duties. Because it is not automatic, my lord. Lordship will kindly read the
Effort 22 is not for that. Effort 22 is where you are otherwise promoted, but you are also given certain other responsibilities carrying greater importance. And if
Lordship
you
will
are,
kindly
then
read
you are
paragraph.
entitled to it.
Lordship will kindly come to paragraph 41 of the same judgment, my lord. Or let us read 39 also, my lord.
Yes.
Rule 22(1)(a)(1) provides that when a government servant is promoted or appointed to a higher post, and the higher post he is promoted to carries duties and responsibilities of greater importance than those attaching to the post held by him, his initial pay in the time scale of the higher post shall be fixed at the stage next above the notional pay arrived at by increasing his pay in respect of the lower post held by him, regularly by an increment at the stage at which such pay has accrued, or rupees 100 only, whichever is more. FR 22(1)(a)(2), the benefit of an additional increment which is available to a government servant under FR 22(1)(a)(1) would not be available to the government servant if the higher post he is promoted or appointed to does not carry duties and responsibilities of greater importance than those attaching to the post held by him. Then going back to 22C, my lord, at paragraph 41, even according to FR 22C, the additional increment was to be granted only in cases where the incumbent on promotion or appointment to a higher post has to discharge the duties and responsibilities of greater importance. Therefore, in cases where on promotion or appointment to the higher post, no duties and responsibilities of greater importance than those being discharged in the post held by the incumbent regularly prior to the promotion were to be discharged by the government servant, the pay fixation formula is provided for in FR 22(1)(a)(2), according to which benefit of additional increment is not to be extended at the time of fixation of pay on the promotional post.
And in his case, what have you done?
We have given the promotion, my lord. That is what has been taken back.
You have taken the promotion.
No, the increment part. We have refixed, my lord. No recovery. We have refixed, my lord.
You
That
have
is-
given him a promotion.
Yes.
Then
At the time of promotion, increment was given. Now that increment now has been taken back, my lord. No recovery, but the fixation has been done in that manner. The entire fixation is at page 88. no?
so what you have given him is an increment which is higher than what he was drawing in the earlier post.
So at the time of promotion, he was given an increment, my lord. That now, the stand is that that was irregular.
Yes.
That is our stand.
What about his appointment and promotion?
The appointment and promotion, my lord, if your lordship comes to the order itself at page 88, the middle portion, the sentence starting with moreover the incumbent,
Page number
88.
88. Yes.
In the middle portion, lordship finds the moreover the incumbent was allowed scale benefit on 1987. Lordship has got it.
Yes.
In the scale of so and so and financial upgradation benefit on 1/1/2007 on completion of 25 years of service. So if 88 is taken as his joining, the date he joins as typist, my lord, he has not completed 25 years.
In which day? On which date?
My lord, he joined as typist on 1/7/88. No, sorry, 13/10/88. So on 1/1/2007, he does not complete 25 years. Because now if his contention is taken to be correct, my lord, then it has to be again everything will have to be redone. Because if 88 is a fresh appointment, the earlier service will go. That is service book. I have annexed, my lord. There also it says it's a promotion. In the service book also it is written as he was promoted. Page 113. It was a departmental test where departmental candidates were also allowed to participate. Page 113, if your lordship sees that. And even at page 116, that note, office memorandum, my lord, clause 4D at 117. Of course, my lord, this came in 2007, 30th of December 2006. Clause 4D. For grade 4 employees, the post of LDA cum typist in the HOD offices, meter reader, etc., to which they are appointed as such against departmental reservation on the basis of departmental test shall be treated as promotion post for the purpose of this scheme. Page 117, 4D.
Now, if he is treated to be, if it is treated to be a promotion,
Yes, ma'am.
then also he is entitled to an increment, isn't it?
That is what we are saying he is not, my lord.
Because there is no higher responsibility.
That is no, that is our stand.
And if it is a fresh appointment?
The fresh appointment, the question of increment will not come, my lord. The pay will be fixed at the lowest level. If what he is saying is correct, that if it is a fresh appointment, he will be at the entry level of the scale. There also he loses out. Other, if his contention is correct, he will not get that increment.
Yes.
Lordship, these are two different things. Typist, my appointment as typist and my subsequent promotion as junior assistant, senior assistant, superintendent are not to be mixed, Lordship. First of all, my initial appointment, fresh appointment as typist on 1988, by virtue of that, I get one financial upgradation on 1/1/2007, which was granted to me in terms of para 5A of the financial upgradation scheme. This is one aspect. This was granted to me and has been taken away. This has no connection with increment. This is one aspect, first aspect. So, and the second aspect is the promotional increments, Lordship. Promotional increments on account of my promotion to the post of junior assistant, senior assistant, and superintendent. Higher duties and promotional increment is a mandate of rule, Lordship. Which rule, Lordship will see? Rule, it is ROP 2010.
One thing, my lord. So far as financial upgradation under the scheme, my lord, Lordship will not record my submission, but I feel that taking it back may not be correct, my lord. Even under FR 22. Because FR 22 speaks of grant of increment. But this is a financial upgradation under the scheme. Whether that can be taken back, that is.
That has been taken back. How, Lordship? It is their stand. They have stated it has been taken back, and it was actually taken back. Lordship will see page 88. Before I go to the rule relating to the second aspect of increments on promotion, Lordship will see page 88. Why it has been taken away? Lordship, two aspects. First aspect, financial upgradation on 1/1/2007. Now, presently I am on that, Lordship. Page 88, Lordship, it has no connection with increment. Page 88, they have explained why it has been taken away. Page 88, Lordship will see, he has read only from moreover. I am reading it from the beginning, para 1. After checking of time to time pay fixation of the incumbent, it is observed that the incumbent was promoted to the post of senior peon on 1/7/1987, allowing one promotional increment, which is irregular. Then they say, again, the incumbent was promoted to the typist in the office of the chairman by order dated 13/10/1988. Then they say, moreover, the incumbent was allowed scale benefit on 1/4/1997 and financial upgradation on 1/1/2007 on completion of 25 years of service. That is the incumbent was allowed 4 financial upgradation benefit, which as per office order dated so and so and clause so and so dated so and so. Also, the incumbent joined as typist, so the notional increment would have been entitled on first. This aspect for a moment, Lordship may keep aside. They say I have been granted 4 financial upgradation, and accordingly financial upgradation as granted on 1/1/2007 is taken away. How taken away, Lordship will see page 89. 89, Lordship will see. There is no date as 1/1/2007. the benefit of financial upgradation, which was granted to me, as they themselves have stated, financial upgradation on 1/1/2007 at page 88, that has been taken away, not there. Page 89, Lordship will see. 89. It is 1/10/2003, 1/10/2004, 1/10/2005, 1/1/2006, 1/7/2006, 1/7/2007. Where is 1/1/2007? The date on which I was granted financial upgradation. Now, reason for taking it away, they have explained it. However, they could not explain it properly. I have understood after repeated reading of this impugn order. They say my senior peon promotion is one financial upgradation. Then promotional increment on senior peon is another financial upgradation. Then they say my promotion to typist, so-called promotion to typist is another financial upgradation. And the scale benefit, so-called scale benefit on 1/4/1997. This is the fourth financial upgradation. So since when, Lordship, a promotion or an appointment has become a financial upgradation? Senior peon, it is not financial, and moreover, it will start afresh from my fresh appointment to the post of typist on 13/10/1988. So after 13/10/1988, I was only granted the scale benefit to the 5th pay commission. Now that has cleared, even that aspect has also been cleared in the financial upgradation scheme. Lordship will see when a person is granted scale benefit as a result of the pay commission, whether he is entitled to financial upgradation or not. Page 117, Lordship will see. Senior peon promotion, promotional increment on senior peon, and fresh appointment to typist are not financial upgradation. Lordship will see page 117 or 118, Lordship will see. From 1988 till 1/1/2007, less than 25 years of service, I have got only one fixation of pay in the corresponding pay scale, 5th pay commission pay scale. That has also been clarified, page 118, para 7. The employees who are enjoying higher scale of pay as per career progression scheme under ROP 1997 shall also be brought over to this financial upgradation scheme, and their pay will be fixed taking into account their presumptive pay in the original pay scale of the post cadre grade. So this is not an embargo. This is not an embargo. So first aspect, financial upgradation, which I was granted on 1/1/2007, it cannot be taken away in this fashion, Lordship. Page 89, I have shown.
We'll pass orders on Monday.
Then second aspect, let me kindly show, Lordship. Promotional increment aspect. Promotional increment aspect, it is a mandate of rule, Lordship. It is not directly come from FR. Lordship will have a look at ROP 2010, page 39. Page 39, Lordship will
We'll
kindly see.
continue on Monday.
Yes.
Monday. For further hearing, Monday. Third Council for Forensics and Party. Monday.
It will be part.
Yes, part.
Obliged.
Yes, Mr. Chaudhary.
My lord. There's a paucity of time now, there's only 10 minutes. This is a matter, Lordship, once heard it for a short time. The petitioner, she had appeared in the APSC examination and secured rank of 35. Subsequently, during the time of appointment, her appointment had been withheld because she is not born from Assam. She is a daughter-in-law of Assam. She is married to a person from Assam, a resident of Guwahati, and way back in 2013, the marriage took place. Subsequently, her appointment was withdrawn and she was asked to produce PRC. So she submitted before the authority that PRC, of course, she cannot have because she never studied in Assam. PRC, Lordship will know it is for only higher education purpose. And then when I filed a writ petition, because her appointment was not given at that time, for 8 months it has been withheld. So I filed a writ petition. Initially in their reply, I'm just giving a short synopsis of the entire case to Lordship, what happened. Initially they say that there is a rule
that original inhabitant only will get the employment. And it is also mentioned in the advertisement. So it came before your lordship because initially when they filed the affidavit, they said PRC is not there. So lordship has pointed out that PRC is for higher education purpose. And then they come up with an instruction that no, she is not original inhabitant. That being the reason she is not given the appointment. So lordship has passed an order initially asking them to produce some office memorandum or some rule, something which defines original inhabitant. Because if original inhabitant, the definition is not there, the document which has been asked, it has been asked for all the candidates. It is voter ID card or PRC document for residential status. So most of the candidate, I will say they may not have the PRC. They might have submitted voter ID card. And I also submitted voter ID card, and at that time there was no problem. The problem arose when some news media telecasted it, and the government at that time realized that no, she is not an original inhabitant of Assam. And that being the reason, because of that suspicion, they withhold at that time, but they have verified it. It is now admitted position that her husband's father, everyone is a resident of Assam. There is no doubt to that. In fact, his grandfather is a freedom fighter. That has also been mentioned in his reply to the government. Now, what has happened when lordship has pointed out, my lord, may kindly have that order. I'll just show that order what lordship has passed on 23/1/2025. If it is on court to lordship. He has waited for a long last February only, 2024 February only she was to be appointed, my lord. My lord, may kindly see this is lordship's order. In the second paragraph, let the matter be listed on 6/2/2025, enabling learned government advocate to produce relevant office memorandum, notification rule, etc. to apprise the court in respect of term original inhabitant as found mentioned in the advertisement issued by the APSC. Because they have no meaning to original inhabitant. Now, how can they say who will be original inhabitant? It is someone who has resided here for 10 years, 20 years, 30 years, or someone who got married in Assam. They will never get appointment here. Nothing has been defined as an original inhabitant. When lordship has given this direction, they moved an affidavit. They filed an affidavit, though there was a long delay in filing that affidavit also. My lord, may kindly see what has been stated in the original regarding original inhabitant in page 111. There are two affidavit which is numbered the same manner. There will be a confusion. So it was filed on 30/4/2025. The second affidavit, 30/4/2025.
Page number
111.
Okay.
Because the previous affidavit is also, they have continued with the writ petition, and the subsequent affidavit also will continue with the writ petition. So there will be some confusion with the page number. 111, para 5. My lord has got it. Yes. May I read, my lord? The term original inhabitant has not been defined under any relevant rules.
111 is para 4C.
That is the confusion, my lord. That is the first affidavit filed by them. There will be another affidavit of additional affidavit. After my reply, there will be another additional affidavit. That will be of 34/2025.
Para 5 thereof.
Yes. 111.
Yes.
My lord, have it? 5. It says the term original inhabitant has not been defined under any relevant rules. So that answers lordship's query that there is no definition of original inhabitant. They have got a rule. They have given it in advertisement. Now a person who is married to an inhabitant of Assam, she has considered herself otherwise which area she belongs now. She belongs to the state of Assam. She claims herself to be a part of state of Assam. She has a passport. She has a voter ID card. She has an Aadhaar card. Everything, everywhere her residential status is Assam. Now, if it is not defined, and then what has been stated, however, in common parlance, as per Black's Law Dictionary, an inhabitant is one who resides permanently and actually in a given place. In the context of Assam, original inhabitant refers to person who along with their parents or forefathers have continuously resided in Assam for generations. This will create lots of confusion because whether this aspect has been considered for the other candidate. Not this why only applicable for one particular person, and this criteria has not been adopted for anyone, and it has not even been defined anywhere. Now, my lord, may kindly see, again they bring up the PRC. Ultimately, it roams around to PRC and 20 years. Now, this 20 years, what will happen, my lord? A logical conclusion of this 20 years, if a person, a lady, is married to a person in Assam, and 20 years is the criteria, the maximum age limit for a general candidate is 38 years. So if that 38 years is to be kept in as a criteria, then not even a single lady who comes and marry with an Assamese or any person from Assam cannot get a job in Assam. They are encouraging child marriage that way. The person who is married in 15 only can get a service here. Otherwise, he will have to be left without any job. He cannot work here. And then thereafter, what has happened, when they don't have a definition of original inhabitant, they bring PRC. This time they come up with a user manual of Employment Exchange Board, where firstly, they put some question to the Employment Exchange Board whether you want 20 years original residence or not. All these questions have been put. And one user manual page in page, my lord, may kindly see, Annexure 2, that will be 117. There it says that Employment Exchange User Manual says that eligibility criteria is any citizen who is domicile of Assam for more than 20 years or whose parents and forefathers have been continuously residing in Assam for a minimum period of 50 years. The applicant must be having 14 years or age or more. Now, why this has been brought to your lordship's notice now? Because the advertisement criteria says that one has to be registered under Employment Exchange Board. Now, she was registered under Employment Exchange Board because the criteria requirement was voter ID card. The Employment Exchange Board has till date not questioned. The APSC who conducted the selection, they did not even file any affidavit. They don't have any problem with our residential status. It is only the government who is stopping me to join the service, only on the basis of this PRC, an original inhabitant, which has no meaning, no definition, and this employment exchange. Now, this employment exchange, it is not a rule. This is not an act. This is only a user manual. Only one page has been given to your lordship. The user manual also, how it has come, who has drafted it, is it a legislative document, nothing has been stated. And then Article 16 specifically says, if your lordship sees Constitution Article 16, there cannot be discrimination on residential status, technically. I am not challenging that rule, because that rule I did not challenge because I claim myself to be original inhabitant. If I leave it to dead and in my entire life, I'll never be treated to be a part of Assam. That was the plea of that lady lordship. She has qualified in the examination and till date she has not been given the chance to join the service. She has secured 35th rank. It is not that, and she still is doing a government job. She is working in T Provident Fund Employment Organization.
Yes.
That is my humble request, my lord, that I think, my lord, here, by giving a vague definition of original inhabitant, because their point of view has changed. Initially, they asked for PRC. Then they said, you need to be original inhabitant. Now they come up with saying that you are not qualified as per Employment Exchange Board. Now, it is, my lord, this judgment of Mahinder Gill, which says, I'll just quote that part, if your lordship allows.
Affidavits.
No, judgment of Supreme Court Mahinder Gill is a constitutional law judgment, which says, it just says that the order of the government is not like fine wine.
That's right.
That it cannot get better every time. Affidavit, exactly, that's what I'm saying. Affidavit, they cannot come up with every time new story. Every time there's a new definition, new explanation given.
All right. Here's Mr. Mazumdar.
The advertisement is not under challenge. The advertisement, if your lordship goes to the page 36 of the writ petition, the it's not a question of developing the case. Advertisement itself contains a clause in clause 6, C, E and F. E says a candidate should be registered in the District Employment Office of Assam. So under the norms, my lord, the petition is not entitled to be registered in the District Employment Office, number one. Number two, a candidate must be an
Where
original.
is that? Where is the advertisement and the conditions?
Page 36.
Page 36.
Starts from page 31. These conditions are at page 36.
Yes.
Under 6E, my lord, E and F. E says a candidate should be registered in a District Employment Office of Assam. The requirement for the document says the requirement for being eligible to be registered with the District Employment Office of Assam is that you should be
You're not registered.
I'm registered.
In the
Registered,
district
but then-
employment?
I'm registered under Employment Exchange.
Then
registered, but then eligibility criteria says it is not entitled to be registered.
no, you only say that the candidate should be registered.
Registered now for being eligible to be registered, it is
It is in
says
page 44.
eligible page 117. Eligibility criteria is a citizen who is a domicile of Assam for more than 20 years. Or whose parents and forefathers has or have continuously resided in Assam for a minimum of 50 years. The applicant must be having 14 years of age or more.
Then what is the basis for having that norm? Is it on the basis of some statute or some policy decision?
So it is a policy decision.
Is it?
Yes. And secondly, the candidate must be an original inhabitant of Assam. Now, inhabitant of Assam is one thing and original inhabitant of Assam is one other thing. The petition is claiming that I have been married to a person who is residing here. Petitioner has not been residing here.
Firstly, under Article 16.
No, that is
can
correct.
Can you curtail?
No, that's what
on
I'm
the
saying, my
basis
lord.
of domicile?
Absolutely, madam. That is, your lordship is correct.
Secondly, is even if you can do it, it must be on the basis of some law, statute, rules,
My
notification.
lord, this
decision.
was a condition in the advertisement. The advertisement is not under challenge. Advertisement clearly says that the candidate has to be an original inhabitant of Assam. What is the meaning of original inhabitant of Assam? Original. Originally, the petitioner was not. Subsequently, after marriage.
No, but she was allowed to appear.
Huh.
Was there no scrutiny by the APSC?
APSC?
Yes, APSC.
I have the instruction that at the time of submission of application from an scrutiny, there was no specific guideline provided to the APSC that who would be the original inhabitant of Assam. So, Lordship, in that case, Lordship, APSC would require the PRC, Employment Exchange ID, or voter card, etc. Lordship. On that basis of those three documents, she was allowed. And it was subject to
Where is your affidavit?
Lordship, we have not filed affidavit, but we have received instruction. Lordship.
Why don't you file your affidavit?
Lordship,
Why your affidavit is not here? Should have been here if you have received instruction.
because the matter was between that, we have already recommended. We have recommended, but the government has not appointed her. That's why the matter was, I think, if required, let's say I'll file one short affidavit.
We don't require, if it is, you think that it is required, it is required.
There is an order, Lordship, where it says that they don't want to file.
We don't require, we record, you did not file an affidavit.
If that my affidavit would.
But if your Lordship want to see the document which were required, it is in my reply in page 121.
No, so you considered original inhabitant on the basis of PRC, voter ID.
And
That's the Employment Exchange ID and voter ID card.
PRC,
no,
petitioner has PRC.
PRC / voter ID. Any of the two. So petitioner had voter ID, I have annexed it.
But it was subject to further verification of the government.
Further verification of that document.
Voter
only.
ID from the state of Assam.
Voter ID from the state of Assam. See, he has everything. Aadhaar card, voter ID, passport, everything in state of Assam.
There's no issue with APSC. That recommended her. But
Well, the district exchange certificate is also annexed, page 44 and 45, employment exchange.
Unless you come up with a definition, what are we supposed to do? We can't define. On a day, you can't just give a vague definition. They must be an original inhabitant. You may have a good reason for it, but it must be substantiated by some material which is capable of being accepted in the eye of law.
The original, I can, original inhabitant means a person who was originally residing here. A person residing in a different state, and then possibly in order to dissuade persons belonging to some other state from competing in this kind of appointments. That
But
was
there is
what-
no policy or decision taken by the state.
This so far as
By having some rules or
no,
statute.
that kind of decisions. In the affidavit,
then-
we have not said anything.
Then Article 16 is applicable. Under Article 16,
Mhm.
can there be a bar?
There, my submission will be for this, if they are not challenging this. Now, original word has to be given
There's
some
nothing
meaning.
to challenge because they applied, they were called for, they
True.
appeared.
True, my lord.
Where is the occasion to challenge?
My lord. And so far as this word original is concerned,
Had the APSC objected that you are not an original inhabitant,
APSC.
then perhaps the question of challenging it.
no, ultimately employment is to be given by the statement. And
No, but you have given the responsibility to APSC. APSC has given the advertisement.
but
APSC did not think it fit to
reject.
requisition from the government as to how do you define this term. They went on selecting. So where is the occasion for any candidate to challenge it when there is no objection from the APSC?
That's there, my lord. Now, the word original has to be given some meaning, my lord. If the word original is given some meaning, the person has to be person.
You have to enlighten the courts as to how to infer the meaning of original inhabitant in the context of public employment.
The word original,
which is again not offensive of Article 16.
yes.
All right.
Let us take a tap on a hearing this so that it can be completed. Sure. The hearing is left.
Yes. Give us a date.
Yes.
I think December.
December.
Lordship is keeping pardoned.
Parted or no parted, it will come.
My request is Lordship keep it pardoned and if it can be taken in the month of December.
We already have a series fixed from 2nd.
Lordship.
2nd of December.
As convenient to your Lordship, I will
So-
not press on the date, whatever Lordship gives. If
That
can-
gives us only the last week. Last week we don't know whether
then
January we can keep it.
maybe on a Wednesday or Thursday, Lordship, any
22nd
Lordship,
January.
22nd.
Let it be 29th, man. I've got some difficulty this week. There's some 29th is Thursday.
29th.
Yes.
Oh, 25 of calendar, sorry.
29th is a Thursday.
29th Thursday, yes, Lordship.
Right. Council for Parties is agreed to list on 29th January 2026.
There's an interim order.
The interim order passed earlier will continue.
My Lord have kept it fast, pardoned.
Not parted, but if we are available, we'll take it up.
Lordship, highly obliged.
Yes. We have already disposed of some matters.
Yes, Lordship.
Are these matters covered?
No, some matters are different, Lordship.
So which are the matters which are not different?
now every matter is different ground lordship. Some matters are related to
The ground of
psychological issues.
rejection may differ.
Ground of rejection all are different lordship. In some psychological issues are involved and jurisdiction also is
Jurisdiction?
jurisdiction I means medical was held on at Bihar lordship in one petition. That's it.
Right, then we'll keep it for some other day. These matters,
Fix
due to paucity of time, these matters be listed again on.
Can it be on 9th of December, Lordship?
we have to fix it.
Also, it may be, time may be fixed. It will be better. Time can be, take the time.
We don't know.
Matters are coming for hearing for a long time, my lord.
Yeah, already 4 or 5 days, I think. My matter is always on last.
All right, 9th.
Lordship, may we pray for listing, for taking up these matters at 2?
At 2.
Because the
9th on 9th
at 2 p.m.
p.m.
Because the only difficulty is, Lordship, they have already started the 2025 recruitment and it will be over by November.
Yes, yes.
9th of December, 2 p.m.
Lordship. Obliged, Lordship.
Obliged.
Item 37.
But here, if the lordships leave, my lord, I am just assisting my sister. I found it, the case is very good case, my lord. But can it be taken on Monday, my lord? I will take a very short time. Only on law
Okay.
point, only on law point.
Monday, we'll try.
Yes.